Please raise your right hand. Do you swear upon the testimony you give to the court that you shoot the whole truth, so help you?
Yes, I do.
Go ahead and have a seat and enter the mic, state and spell your name for the court.
Freddie Coleman, Freddie Coleman, Coleman.
Good morning, Lieutenant Coleman.
Good morning.
How are you employed?
City of Atlanta Fire and Rescue.
How long have you been employed with City of Atlanta Fire and Rescue?
6 years.
And what is your current title?
Fire inspector.
Okay. As a fire inspector, can you tell the court what your duties are?
I inspect commercial buildings and make sure that they're in compliance with fire code.
Okay. In this position, do you supervise any other inspectors?
No.
Okay. And are you a sworn officer in 98-1 of the municipal code?
Yes.
Does this give you the authority to issue code enforcement violations as well as fire code violations?
Yes.
Are you familiar with the property address of 2110 Peachtree?
Yes.
And what is at this address?
It's a nightclub.
Okay. And,
1145.
okay. Did you do an inspection at that property address?
I tried to conduct an inspection in December 14th
Of what year?
of 2023.
And when you say you tried, what stopped you from doing your inspection?
It was during the daytime, and usually businesses aren't open during that time, but when I went to the door, they had a stop work order on the patio door.
Okay. And what were you there to do an inspection for?
1145 is a public assembly. We go to those businesses once a year, so I was there to do a fire permit for them.
Okay. And once you saw the stop work order, what did you do then?
I immediately, I couldn't do the inspection because the building wasn't safe, so I went into the system and put them in follow-up.
Okay. Did you go into the building at all?
No.
Have you ever been inside the building of 2110 Peachtree?
Yes.
And when did you actually go in the inside?
The last time I was at the business, they were operating on, we do night observations, so they were operating on March 2nd
Of what year?
of 2024. It was a Saturday.
Okay. And you actually went inside of the establishment?
Yes.
And would you say the establishment was operating as a restaurant or a club?
Nightclub.
Okay. And what gave you that indication?
The time frame that they open up, it's about 11:30, 12 o'clock. Didn't see any food, and then the amount of traffic that's in the area, foot traffic, and it's just very nightclubish.
Okay. What is the maximum occupancy of 2110?
422.
Okay. Let me take you back to December 14th of 2023, I'm sorry. When you were unable to do your inspection. You say you were unable to do your inspection because you saw a posting?
Correct.
Okay.
There was a placard
Okay. And what did that placard say?
that this building, it's a stop work order placard, and that the building was unsafe and the work had to cease.
Okay. And does fire normally cease doing inspections if a building is deemed unsafe?
No, we don't do anything to it.
Okay. How many exits are available at this particular establishment?
To my knowledge, 3.
Okay. And where are they positioned?
There's one in the front, there's one on the right side, and then there's the one on the back side towards the patio.
Okay. So there's a door that's leading to the patio, is that correct?
Correct.
But the patio itself is deemed to be unsafe.
Correct.
Thank you. No further questions.
Cross?
So when you went on December 14th, that's the day you went to conduct the annual inspection, saw the stop work order on the patio door, correct?
Correct.
And when you say that the building wasn't safe, you're in referencing to the patio or the entire building? You're just saying because you saw the stop work order, the entire building or the patio was unsafe?
When I see a placard on anything, On any part of the building, I'm gonna say that that's the whole building.
Okay. What is the, what is the usual protocol when you deem a building unsafe? Is there anything that you can do as a fire inspector to force the building to come into compliance? Like, what's the usual protocol when you go to do an inspection?
When fire puts a placard on the door, there's a normal protocol that we follow, to get in contact with the business owner and make sure that they follow that, compliance. But this placard was issued by buildings, and that's outside of the scope of my job, so I immediately read the sign, went back to my supervisors and let them know and entered the information inside of a cellar.
Did you make any contact with the business owner at that time or after that visit?
I didn't.
Did you make any contact with building directly to address your concern at that time?
Yeah, we did get in touch with buildings, my supervisor.
Are you aware, do you have knowledge, are you aware, you said you've done some night observation, are you aware that 1145 at times hires off-duty fire marshals?
I have seen them there.
You have. So have you ever expressed your concern to the off-duty fire marshals about 1145 being deemed unsafe based on your previous statements?
Could you say that one more time?
Have you ever expressed your concern about the building being unsafe to fire marshals that are working duty there?
No.
Have you ever heard any, you speak about the occupancy, have you heard any concerns from any fire marshals about the building? Have they come to you and expressed any concerns about the building?
No.
I mentioned earlier that you deem 1145 a nightclub based on the hours of operation. Is that just your personal observation, or is there something else that leads you, is there any other type of knowledge that tells you that the hours of operation is what a nightclub is?
I've been doing this for 6 years, so if I go to a business and it's 11 o'clock and you don't have one person in the building yet, and when I come back at 12 o'clock and you have a line of people standing up there, so to me, it's just my professional observation that they're operating as a nightclub.
Okay, so that's your professional observation, but it's not based on any understanding of what the, it's not based on understanding of what the city classifies a nightclub as, correct?
Say that again now?
It's not based on your understanding, it's not based on your understanding of what the city classifies a nightclub as, correct?
I wouldn't agree with that.
When you say places of public assembly, I heard you mention that term earlier. Can you explain a little more about that?
Places of public assembly is when it's 50 or more. That's considered a public assembly.
So can't a restaurant, a nightclub, and an event facility all be classified as place of public assembly?
Oh yeah, they are.
So
Yeah.
for purposes of the fire code, it doesn't matter what the designation of the business license or the alcohol license says. It matters whether or not that business all that matters to you is whether or not it's labeled as a place of public assembly and how you interpret the fire code, correct?
Correct.
That's all.
Come on.
Let me show you, this is your exhibit, it's just a copy of your exhibit.
Yeah, this is a copy of exhibit number 6 from the city.
I see,
May I approach with
yes. And if you want the actual exhibit, it's with the court reporter.
Okay. So this has been submitted by the city of Atlanta as the warning that has been posted in front of the building. Is that the warning you were referring to that you saw when you went to inspect the building?
Yes.
Okay. And where was exactly that posted?
This posting was on the side of the door with the patio door.
The patio door, okay. But you testified today that you assumed that it means that the whole building was unsafe, correct?
I didn't say assume. I said to me, if I see a placard on the door, the building's unsafe.
Okay, so when you say to me, that is your idea of what?
That's my interpretation of what a placard means.
Okay, but you say you contact the office or buildings that issued that actual warning, correct?
Correct.
Did they explain to you that this warning was only referring to the addition, which is that patio area in front of the building and not the whole building?
My supervisor contacted them,
Okay,
and from my understanding, the patio was deemed unsafe, or that area or whatever was deemed unsafe because of the business didn't take proper channels to get it built.
okay. And just let me clarify too, that I do not represent the business, I represent the actual landlord, the owner of that property and other properties around on that area. Have you ever tried contacting Bennett Street Properties or the landlord regarding the fire issue or any other issue?
No, ma'am.
Thank you.
You're welcome.
Any redirect?
No, Your Honor.
Can he be excused?
Yes,
Thank you.
Yeah. The city calls Daryl Jones.
You raise your right hand. Do you swear upon the testimony you give to the court is the truth, the whole truth, so help you?
Yes.
Go ahead and have a seat and answer the mic, state and spell your name for the court.
My name is Daryl Jones, Darryl Jones.
Good afternoon, Mr. Jones.
Good afternoon.
Okay. Mr. Jones, can you tell the court how you're employed?
I'm employed full-time with the city of Atlanta,
And what is your current title?
manager of audits.
Okay. And how long have you been working for the city of Atlanta and as manager of audits?
For 2 months.
And prior to working for the city of Atlanta, can you tell the court about your experience in audits?
I have over 30 years of audit experience through the state, Georgia Department of Revenue, as well as in banking.
Okay. And what are your current job duties?
Basically, I assess compliance records through multi-years, final closes and renewals. I'm responsible for also system audits and taxes for all businesses and risk assessment for their revenue.
Okay. And do you have particular knowledge of regarding the percentage of sales for a restaurant?
Yes, I do.
Okay.
Yes.
And are you familiar with the property address of 2110 Peachtree?
Yes.
And how are you familiar with that property address, Mr. Jones?
That property address came up as it was auto-generated through our system, and in doing so, it came up for me to audit.
Okay. So is this random?
It's random, yes ma'am.
Okay. And did you perform an audit of 2110 Peachtree?
Yes, I did.
And what years did you include in your audit?
2021, 2022, and 2023.
I'm going to show you what's been marked as petitioner number 8.
Okay. Thank you.
Mr. Jones, do you recognize that document?
Yes.
Can you tell the court what it is?
This is the executive summary of 2021 Peachtree.
And did you yourself prepare that document?
I did.
And how was the report generated? How did you draft that audit?
This is drafted off of me doing the audit of this business based off their gross receipts that they submitted to us, and it will be, this is also generated through their business records.
Okay, and is this a report that you generate in your normal course of business as being manager of audit?
Yes.
Okay. And around what time did you do this audit?
This is around May 13th, 2024.
Okay. And did you record your audit into any custodial record for Department of Revenue for City of Atlanta?
Yes, ma'am.
And what was that?
It's on Microsoft Excel as well as in our intergov system.
Okay. And do you have a terminal connection to intergov?
No, I don't. When you say terminal, I'm sorry, I didn't understand.
Can you log on from your desk to?
Oh, yes, ma'am.
Okay, and are you an authorized user of intergov?
Yes, ma'am.
And based on your report, are the majority of the sales derived at 1145, the establishment that's at 2010 Peachtree, from alcohol or food sales?
It's a combination of both, but according to my report, they've exceeded what's considered our 30% threshold for alcohol to food ratio.
So in 2021, what was the percentage of their sales that was from alcohol?
2021, the percentage was 0.359, which is rounded up 36.
Okay, and what was the percentage for food in 2021?
It would have been 64%.
Okay, and in 2023, what was the amount for alcohol as alcohol?
For 2023, it was 0.21,
And
and the food would have been 79.
Okay. And based on your report, does the alcohol sales exceed the food sales?
Yes, ma'am.
Okay, and did you, after you drafted your report, did you request additional information from the owner?
Yes, I did.
And did you write a letter to the owner asking for that additional information?
Yes, I did.
And what additional information did you request so that that your audit could be thorough?
I requested the completed federal and state tax returns.
What else did you request?
So that was what I requested, but we also looked for gross receipts, POS, and things like that, and it was all listed in the letter, but I basically needed the federal and state tax returns.
Okay, and have those documents been provided to you?
No.
Based on your audit, would you say this establishment is a club or a restaurant, Mr. Jones?
I would say it's a club.
Thank you, nothing further. I'm sorry, at this time I'd like to tender in evidence petitioner number.
I'm gonna object to that to the degree that it calls for speculation in this report. You look at the report, it talks about, I believe this business is a nightclub, it appears to be a nightclub or lounge, and we haven't gotten to this yet, but to the extent that he says it appears to operate as a nightclub or lounge, lounges doesn't even have a definition, or not lounges have a definition in the business license ordinance. So it's a lot of speculation in this report, and it doesn't even appear to be completed. So I object on those grounds.
And Your Honor, I asked him if it was a restaurant or a club, but as for the document itself, the city has laid the proper foundation that it is a business record. He himself made it. He himself has testified that that the custodian of the records is intergov, and he's an authorized user, as well as he has a terminal connection, and it's kept in the ordinary course of business.
Okay, I'll allow it and I'll do it the proper way.
How you doing, Mr. Jones?
Doing great, thank you.
So earlier you spoke about this was an auto-generated audit, and that when you get, can you explain more about how that comes about, or how does the system auto-generate audits, or what's it based on?
In our system, what's called the intergov, we have all the business records of all the businesses that are registered in the city of Atlanta. And every day I get a report based off of things being discrepancy in alcohol, they drink by the tax, as well as if the gross receipts or gross revenue is 30% one way or the other, up or down throughout the course of the year for gross receipts annually.
So this was completely random. This was a completely random audit, what you're testifying to?
All the audits are random, yes.
So you prepared this report that the city attempted to, that the city's placing evidence, correct?
I prepared this report, yes.
So if you look to the first page, it says that, well, not the second page, it says that on May 13th, Mr. Bala / Lieutenant Cotter requested a 2023 audit of 1145 DBA 1145 restaurant, which is licensed as a restaurant to sell liquor, beer, and wine for on-premise consumption, live entertainment. The owner's name is Dijabril Daffy. The restaurant is located the address is incorrect, it's 1110 Peachtree Street. Based on the recent incident and multiple reports, an audit shall be performed. Is that accurate, or is that accurate? Is that what you typed in the report?
Well, CFO Bala, he's requested all audits for all the city. He's the CFO. We are the designees, so that's the wording for when we do audits. He's the one whose name will be at the top all the time.
Okay. But if you're the one that produced this, or is this language saying that he and Lieutenant Kyra both requested an audit, or who requested the audit? Because your earlier testimony that it was an auto-generated audit, not that anybody requested a specific audit.
That request is from me. When I say they requested audit, that's something they request from me, not the fact that they requested me to do an audit. They get copies of all the audits.
Oh, so you were requesting the audit on that day?
No, I performed the audit, and they have to see a copy of the audits that I do. Sometimes they'll pick audits to look at.
So when was this audit? When did this audit begin? That's what I'm confused about, because the background and context that I'm reading it states on May 13, which happens to be one day after the shooting at 1145, and it also says it doesn't say based on calculation of the system. It says based on the recent incident and multiple reports, an audit should be performed. So I'm just trying to understand if it was random or if this was requested from Lieutenant Cotter or someone else. That's what I'm trying to understand.
The audits are random, and the request is they can request any audit from me.
Mhm. So when did this audit that you prepared, when did you begin working on this audit?
May 13th was when I sent the letter out, and it got into my system probably before then. But what happens is daily, we get reports, and I get the business records, and I look through them, and if it has anything up or down 30%, the alcohol ratio is higher than 30%, they automatically are part of our random process.
But you can't verify under oath right now with certainty when you began this audit today. You can't verify that. You can't verify the exact date, can you?
I can't verify the date that it was part of the business record, but I can verify the date I actually sent the record out, and that was May 13th.
May 13th, so the day after the shooting. Okay. Another question: Have you ever audited 1145 in the past prior to this? Did the system ever tell you or prompt you to audit 1145 prior to this audit?
Well, no, I've been with the city only 2 months, so I'm just starting with all the processes with that.
Well, I have no further questions.
Okay, thank you.
I have no questions.
I have redirect. Mr. Jones, when did you actually finish the audit?
Well, the audit is not finished because I hadn't received the tax returns.
Okay, but your letter is dated May 13th, 2024, is that correct?
Correct.
May the court take judicial notice that May 13th was on a Monday?
Do you guys agree to let me look at my telephone?
That's fine.
Okay. What year?
2024.
May, did you say, what day?
May 13th.
May 13th is a Monday.
Okay.
I'll take
So,
such notice.
so that was a Monday after May 12th of the incident, the shooting, correct?
Correct.
Okay, but you had already finished your audit, isn't that correct? Or finished the part of the audit where you needed additional documentation, is that correct?
That is correct.
Okay, and can you distinguish between performing the audit and when you were asked, they were requested to look at your audit?
Okay, and that was the May 13th day. So on the audit, if you see the letter I have, it was scheduled to actually be official June the 3rd. And because of that, we give them time to send all the tax returns and all the requested information. And after June 3rd, we hadn't received anything, and we're still waiting on those returns.
Okay, so prior to May 13th, which was that Monday after the tragedy, you had already received gross receipts and performed an audit on 1145.
I had received the gross receipts, and I began the process. I hadn't performed it.
Okay, thank you, nothing further.
Any requests?
recall when you sent the information, the request for information to 11:45, it was after May 13th when you requested information of them, right? Correct?
It was May 13th, and I have it on here, yes.
Were you aware that Mr. Daffy was out of the country for a majority of May and June?
I've had no contact with them.
Okay, that's all.
Okay.
Anything for Bennett Street? Okay, anything there?
Nothing further, Your Honor.
All right, any reason he can't be excused? You're excused.
Thank you.
Thank you.
The city calls Benjamin Gaines.
Thank you.
Did you say Benjamin Gaines?
Yes, yes, Your Honor.
Raise your right hand. Do you swear upon the testimony you give to the court, it's the truth, the whole truth, so help you?
Yes, I do.
Go ahead and have a seat, and it's the mic, state and spell your name for the court.
Benjamin Gaines, BenjaminGaines.
Good afternoon, Mr. Gaines. How are you employed?
I'm employed with the City of Atlanta,
How long you been employed with the city of Atlanta?
10.5 years.
And what is your current position with the city of Atlanta?
I'm the Senior Collections Manager with the Office of Revenue.
And how long have you been employed in that position?
14 months.
And prior to that, what were you employed with in the city of Atlanta?
The Department of Watershed Management.
Okay. And what is your current job duties?
I'm the Senior Collections Manager for the Office of Revenue.
Okay. And are you familiar with the property address of 2110 Peachtree?
Yes, I am.
And what's located at that property address?
It is a restaurant lounge.
Okay. Do they have a valid business license?
Yes, they do.
Do they have a valid alcohol license?
Yes, they do.
And is that, how is that property licensed to operate?
The property is licensed to operate as a restaurant.
Okay. And as a restaurant, are you authorized to ask for records from that particular business?
Yes, we are.
And what records are you authorized to ask for?
Previous Georgia tax returns and monthly alcohol sales receipts.
Does that business have an alcohol license?
Yes, it did.
And what day of the month are they supposed to submit their alcohol receipts?
The 20th of each month.
Okay. And have they been in arrearages on presenting those particular documents to the Department of Revenue?
Yes, they've been inconsistent since 2022.
Okay. And can you tell the court how they have been inconsistent?
The business would report 1 month and defer for another 7 months, being non-compliant, true up 1 month, delay another 5 months, true up at the time, and the pattern has continued for the last 2 years.
And also, Mr. Gaines, I'm sorry, let me back up. At any time, did you ask for the business to be cited for being in violation of not producing their alcohol sales?
Yes, ma'am.
And was these citations issued?
The citation was attempted. The attorney representing the client spoke of meeting up with APD.
Objection, you say?
Okay.
Why was the citations not served?
The client was not available. We solicit my department for after-hour establishment. We solicit the services of APD to assist us with executing citations for those after-hours locations. And in my collaboration with my point of contact on the APD side, they were unable to serve the citation to the individual. There was a commitment to come in to be cited, and that never took place.
Okay.
Objection to, that's hearsay, speculation, says commitment.
How do you know that?
The Lieutenant Carter, he's on the witness panel as well. He will testify to that.
Okay. Thank you. Let's move on. Mr. Gaines, when the sales receipt are submitted to you, is it with tax information, or does the city of Atlanta operate on the honor system?
Honor system based upon the tax percentage that should be provided to the city.
Okay, so the business just gave you numbers,
That's correct.
okay? And so you articulated what the tax would be on what the information they gave you,
That's correct.
okay? So Mr. Gaines, you never received the taxes, the federal taxes, is that correct?
That is correct. We're still waiting on those
Okay.
documents.
And when did you request those documents?
It was early May of this year.
Okay. And as of today's date, you could not qualify without looking at their tax returns, what their actual sales were.
That's correct.
Okay. Mr. Gaines, you're familiar with the alcohol ordinance, correct?
Yes, I am.
Can a restaurant sell distilled liquor by the bottle?
They should not be selling distilled liquor by the bottle. It should be by the drink.
Okay, so would that take away from the numbers that, if you knew or had reason to know that 1145 was selling liquor by the bottle, would their tax by drink numbers be correct?
If I knew the tax by drink numbers that they provided to the city would not be correct.
Okay. Mr. Gaines, can a restaurant sell a section for $750 and include 3 bottles of distilled liquor?
No, they can't.
Thank you, no further questions.
How many businesses have you cited? I don't ask that question actually. You mentioned that 1145 has been inconsistent. Was it inconsistent paying the sales by the drink taxes, or inconsistent filing and paying the sales by the drink taxes?
Both, sir.
Both since 2022, correct?
That's correct.
Have you ever given them any citations ever since 2022 for failing to pay or file the sales by the drink taxes?
My team have not done so.
Have you attempted to cite them prior to the most recent attempt you just referred to ever? Have you ever attempted to cite them for not paying sales by the drink taxes?
My team have not. No.
When you mentioned that recently you were attempting to cite the business, around what time was that you were attempting to cite them?
Early May.
Early May. Can you be a little more specific? Was that before or after the May 12th incident that we've all been talking about?
It was after.
After. And what prompted you to look into the sales by the drink numbers for 1145?
In early April, my team, we ran some analysis on after-hour establishment throughout the city, and there were approximately 21 establishments after hours that were non-compliant with their remittance account. My team, we partnered with APD to assist us in facilitating those after-hours establishments bringing their associated remittance account into compliance with the Office of Revenue in accordance with city ordinance. So the process started in early April.
So out of those after-hour places that you identified, did you cite any of those places?
Yes, the process took longer than anticipated because some of the business owners were hard to locate. So yes.
Now, the normal process for what is, please explain the normal process when a business, when you notice they've not been filing their sales by the drink taxes, when they haven't been filing or paying, what's the normal process to get them into compliance? Can you explain that for the court?
They receive a monthly communication from our database. The next step is my team, we will conduct a courtesy visit, trying to do the soft approach to encourage them to bring their account into compliance. If they fail to respond to those two attempts, then the third step is to issue a citation for violating the city ordinance.
Did you issue a courtesy visit to 1145 prior
There
to
was,
trying to cite them?
there was an attempt when I discovered that it was after hours, and I did not want to jeopardize my staff by going to that establishment after hours. So that's when the collaboration with APD was coordinated.
So, you mentioned that, okay, so, isn't it true that a business that is not paying their sales by the drink taxes can have their business license or alcohol license made inactive?
Okay, it is only during the renewal period. So during the renewal process, if their remittance account is not in compliance, their alcohol license will be placed on hold, or the renewal process, the renewal will be placed on hold until they bring the associated remittance account into compliance. Likewise, if the alcohol license is not in compliance, at the time of the business license renewal, the business license renewal application will be placed on hold until the associated alcohol license is brought into compliance.
So Richard, are you familiar with the renewal deadlines are for the business license and alcohol license?
Yes, I am.
Isn't it true the renewal deadline for alcohol license is December 31st, correct?
That's correct.
And the business license renewal deadline is January 15th, correct?
No, sir, that is not
I mean,
correct.
February 15th, my apologies.
Yep,
February
February
15th. So essentially, there's no way for a business to continue to operate without paying these taxes because they have to come into compliance each and every single year prior to renewing their license, correct?
We see non-compliant offenders every day.
Yeah. But those non-compliant offenders will not be able to act in non-compliance. They will not be able to renew their license if they're in non-compliance at that time, correct?
We see non-compliant businesses operating inside the city of Atlanta without an active compliant business license, and we see non-compliant businesses operating without an active alcohol license.
Have you ever seen 1145 operating without an active business license from your experience? Have you seen them without an active business license?
No, I haven't personally.
Okay. You speak about restaurants that serve liquor by the bottle. I'm sorry, it was nightclubs that serve liquor by the bottle. No, restaurants. What makes it illegal for a restaurant to serve liquor by the bottle? In your knowledge.
The city ordinance is very clear. Article 6 in reference to distilled spirits and how those things should be sold.
Are nightclubs allowed to sell liquor by the bottle under the alcohol code?
They should be selling by the spirits as well.
Are event centers allowed to sell alcohol by the bottle?
They should be selling by the spirits as well.
Are bars allowed to sell by the bottle?
They should be selling by the spirits as well.
So essentially every business, so it's not specific to restaurants, any business that's serving alcohol shouldn't be selling by the bottle in your interpretation. Is that what you're saying?
They should be selling by the spirits.
Okay, that's all I have.
I have no questions.
Redirect.
Mr. Gaines, isn't it true that you can sell wine by the bottle? A restaurant can sell wine.
Thank you for that correction. Yes, yes,
Okay.
you can.
Okay, but distilled spirits, which is liquor, is sold by the glass because it's taxed. Is that correct?
That is correct.
Thank you. Nothing further.
I just want to make one correction for the record. When you said after hours, you're referring to after the hours that you work, not after Can you clarify what you mean when you say after hours and describing after hour businesses?
Yes. My team typically works from 7 to 4:35. And so businesses that open up after 5 o'clock, it will put them in a situation where I have to pay them overtime. So I partner with another department within the city to help us address some of those non-compliant businesses.
And last question, you're unaware of anything in the code or anything in the business license code that prevents establishments from selling, as the city said, selling sections. There's nothing in the code that you're aware of that prevents any business from selling sections, whether it's restaurants, bars, clubs.
I'm
To your knowledge.
not aware, it may be in the ordinance, sir.
That's all, thank you.
Any redirect?
No, Your Honor.
Anything for Bennett Street? Any reason he can't be excused?
No, Your Honor.
City calls Lieutenant Mark Carter.
Raise your right hand. Do you swear upon the testimony you give to the court is the truth, the whole truth, so help you? I do. Go ahead and have a seat and into the mic, state and spell your name for the court.
My name is Lieutenant Mark Cotter, spelling the last name Cotter.
Good afternoon, Lieutenant Carter. Where are you employed?
City of Atlanta Police Department.
And what is your title?
Police Lieutenant, Unit Commander for the City of Atlanta Police Department's License and Permit Unit.
And how long have you been with the City of Atlanta Police Department?
27 and a half years.
And how long have you been a lieutenant in the License and Permit Unit?
About 5 years.
And can you describe to the court your duties as a lieutenant in the License and Permits Unit?
Yes, the License and Permit Unit is split up into two sections. The first section is the administrative part of the License and Permit Unit. The admin unit handles the processing of alcohol licenses, schedules applicants to appear before the board, conduct site visits. We also process about 22 different types of permits through different permits throughout the city. Those permits vary from hotels, rooming houses, adult dance halls, teen dance halls, gaming rooms, bail bondsmen, massage establishments, and fortune telling, and several other different types of permits. The enforcement side handles compliance checks as well as conducting alcohol investigations to ensure that businesses are in compliance with all state laws and city ordinances.
Okay, so Lieutenant Carter, it's fair to say that you are, have knowledge on the whole entire alcohol process or permitting process for restaurants or clubs in the city of Atlanta?
Yes.
All right, and the particular, what is the particular code that dictates the alcohol code for the city of Atlanta?
Chapter 10.
All right, and I want to show you an exhibit. This should be pre-marked petitioners exhibit 19. May I approach Your Honor?
Yes.
And Lieutenant Carter, can you, tell the court what petitioner's, 19 is?
Appears to be the chapter 10 ordinances, which are the alcohol, laws for the city.
Okay, and that top page, have you seen this code before?
I haven't seen this packet before, but I've seen these ordinances before.
Understood. And the front page of petitioner's 19, what is that top sheet?
Looks like it's from the Office of Municipal, Court Clerk.
Okay, and that appears to be a certified copy of chapter 10, correct?
It does, yes.
All right, Your Honor, we move the tender exhibit 19 into evidence.
Any objection?
No objection.
It's submitted, you can produce it.
Thank you, Your Honor. And so, Lieutenant Carter, according to that code, what licenses are required to operate a restaurant in the city of Atlanta?
You need a state license, and you need a business license, as well as a city alcohol license.
Okay. And are there differences in the licenses between a nightclub and a restaurant?
Yes, there's different laws that pertain to different establishments.
Okay, and so for what kind of licenses would you need to operate a restaurant?
Well, you would need a letter from the Fulton County Board of Health or DeKalb County Board of Health, depending on where the licensed establishment is in the city, like a food service permit. You would also need, I believe, a grease trap permit, business license, city alcohol license, certificate of occupancy.
Is that different from what would be required if you were seeking a licensing for a nightclub?
It would pretty much be the same type of, you still need a business license, state license, alcohol license, but the classifications they'd have to operate different because as a nightclub, per city ordinance, they have parking requirements where a restaurant does not. Also, a nightclub has to close at a certain time and get patrons out of the nightclub or bar, where a restaurant just has to stop serving alcohol after a certain time. So there's different laws as to how you operate a particular business.
Are there different days of the week that a restaurant could operate in the city of Atlanta as opposed to a nightclub?
Yes, restaurants can stay open 7 days a week. A nightclub cannot open on Sunday, and per hours of operation, I believe the earliest they can open again is 9 o'clock a.m.
And for a restaurants, are there any requirements in the code that require a restaurant to have a minimum amount of days to be open?
Yes, if you review the chapter 10.1, where under the restaurant definition, it says they have to serve at least one meal 6 days per week.
And so if an establishment that's licensed as a restaurant is not operating 6 days a week or selling one meal a day, would you agree that they're operating outside of their permitted use?
Yes.
I'm gonna ask you about 2110 Peachtree Road, Atlanta, Georgia 30309. Are you familiar with that address?
I am.
And what is at that address?
1145.
Okay. And how are you familiar with that address?
Since I've been assigned to license and permits, we have done several compliance checks at that location as well as several others in that particular area. We've also done due causes and other different businesses that have served search warrants at different businesses in that area.
Okay. And so you're familiar with the licenses for 1145, correct?
I am.
All right. I'm gonna show you another composite exhibit that is marked on petitioners 1. May I approach your honor?
Yes.
Do you know what that document marked as petitioners, one is?
Yes, it is a copy of the, it looks like, the alcohol beverage certificate, which is the city alcohol license. And it appears this other one, this other document is the operation tax registration certificate, which is the business license.
Okay, and can you read for me what the designation of the restaurant license? The business license?
The business license?
Yes,
As far as like classification,
yes, business type.
business type, it says full service restaurant.
Okay. And then, on page 1, where it says business type, can you answer what is the business type reflected on page 1?
Business type is restaurant, liquor, beer, and wine, live entertainment.
Okay, and what does that mean? Can you describe to the court what restaurant/liquor, beer, and wine with live entertainment means? Can you describe what that means?
Yes, they have been licensed by the city, approved for on-premises consumption of liquor, beer, and wine, and also allowed to provide live entertainment at their establishment.
Okay, and can you describe what live entertainment means? What can they do with it as being licensed as a restaurant with live entertainment?
But based on reviewing 10.1, the definition of entertainer is permits a performance by any person at an establishment.
Okay, but live entertainment, it doesn't allow you to operate at the club, does it?
No, it does not.
Okay, and so those same restrictions that we went over a moment ago about an establishment having to be open 6 days a week, that still applies to a business being classified as a restaurant with live entertainment, correct?
Yes, the restaurant is allowed to have performances by people or persons, but it still doesn't allow them to operate as a nightclub because they're classified as a restaurant.
Okay. And also under the code, there are other restrictions how the revenue is derived from a restaurant, correct?
Correct.
And what percentage of that revenue from a restaurant is supposed to be food?
50%
Okay.
of total annual gross.
All right. And based on your understanding, what percentage of food sales is derived from at 1145?
I'm not sure. As far as like me personally knowing how many food sales, there has to be 50%. I don't know about the audit.
So, Lieutenant Carter, did you review an audit by Department of Revenue, City of Atlanta?
I did.
Okay, and based on your review of that audit, what was your understanding of the percentage of alcohol sales versus food sales?
I didn't see a percentage. I saw, I believe $4 million was accumulated in 2023. I think $300,000 was another year. I didn't see a percentage in there.
Sure. I'm gonna hand you a copy of it. Oh, the judge, I think that's P6, Judge. You have the audit report?
Yes, sir. Thanks.
So, Lieutenant Carter, have you seen this document?
Yes.
And is this the audit report we were just referring to?
Yes, it's the audit report that I read.
Okay, and so if you turn to page 3, turn to page 3, they have, starting in 2020, there's a number there's a percentage. Do you see the percentages that are broken down from 2020 to 2021, 2022, and 2023?
Oh, this, I got that on page 4.
Page 4.
I object to that to the extent that this is not a report he created, and there's nowhere in that document that it says that those are the alcohol to food. I mean, that document has some numbers and percentages. That doesn't state that that's the percentage of food to alcohol sales in that document. I don't think Lieutenant Cotter can testify in the meeting of those percentages or numbers.
Well, the document's already in evidence, so if you want to present it through some witness, but it doesn't sound like he's going to be able to explain it. So feel free to cross-examine him on his expertise in that.
And so, Lieutenant Carter, on page 4, do you see the percentages contained at the middle of the page?
I do.
All right, have you seen a report like this before?
No, this is the first time I've seen a report like this.
Got it. So, and so for 2020, you see a percentage that ends in 0.0499629, which will be about, I assume 50%.
Yes, but I don't know what's that referring to, the alcohol sales or the food.
Understood. All right. So let me point your attention to 1145. So based upon your knowledge of 1145, let me ask you a different question, Lieutenant Carter. Are there instances, have you seen before in your experience where folks or businesses attempt to hide behind a restaurant classification?
Yes.
And why would they do that?
There's a restaurant doesn't have to close. They can stay open 7 days a week. They can have people under 21 in there, which is why a lot of people try to get the restaurant license.
Okay. And so, turn your attention to May 12, 2024. Are you aware of a shooting that occurred inside of 1145?
I was.
Okay. And did you visit that property on that evening?
I did.
All right. And why did you visit the property that evening?
I heard myself as well as other investigators from the License and Permit Unit heard the call come up over a detective dispatch that multiple people have been shot with one person being deceased. We then started to the location. When we arrived at the location, we met with the night commander. We then assisted Sergeant Skeens with interviewing employees as well as clearing out the building. I then walked through the crime scene and observed the 2 individuals deceased inside the location.
And upon your arrival on the scene, you went inside. What did you observe? Was it a nightclub? Was that the first time you've been in 1145?
No, I've been in there several times.
All right. And what was, in your opinion, is 1145 a nightclub or a restaurant?
It is classified as a restaurant with live entertainment.
All right. Do you believe that they are within that classification during their operations?
It's hard to answer that question without putting in the totality of the circumstances. If you look at the hours, the lighting, the advertisement that they're only open 5 days a week, I would say no, they're not operating within the guidelines of a restaurant.
Okay. On May 14th, when you responded to the deceased persons at the property, was that the first time that you had heard about shootings occurring in 1145?
No, I believe I responded May 12th, not May 14th.
May 12th. I apologize.
I've heard shootings at that location. I've reviewed incident reports of shootings in that area as far as tying it to that particular business now.
Okay. Have you received complaints from the community regarding traffic or noise?
Yes.
At 1145?
Yes.
All right. And did that cause your office to do compliance checks with 1145?
We have done compliance checks at 1145, yes.
And do you know any of the results of those compliance checks?
They were in compliance.
And they were in compliance because they had served the meal that day, or why were they in compliance when you went out those times?
Based on the observations when we went out there, they were in compliance. We didn't do a deep dive into the business without, a reason. There's just too many businesses in the city to do those type of investigations unless we have some more to go on.
Gotcha. And so, based on what you know now, is it your intent to bring a due cause package for 1145?
Yes.
All right, and can you explain to the court what a due cause package is?
A due cause package is an administrative investigation as to why this license should be suspended with a fine or revoked based on violations of Chapter 10 or other laws or ordinances.
And do you believe now that they have violated their license to where the license should be suspended or revoked?
Yes.
And what do you base that on?
Based on the incident that occurred on May 12th where 6 individuals were shot with 2 deceased, I believe under Fuel Review 10109, Section 12, it's a failure to supervise based on that incident. And also further investigating, I went on the website where I noticed they were only open 5 days a week. I believe they're closed on Mondays and Thursdays, which would be a violation of 10.1, the definition of what is considered a restaurant per Atlanta City Code. Also, while speaking to Mr. Gaines, he advised the last time they paid tax by the drink was in November of 2023, which would be a violation of the requirements for tax by the drink.
And let me take a step back, Lieutenant Carter. Can you explain to the court what failure to supervise is?
Failure to supervise is that the agent for any type of alcohol license did not act appropriately for the safety of the patrons or employees inside their establishment. It covers the licensed premises as well as parking areas that are controlled by that particular business.
So Lieutenant Carter, whose responsibility is it to provide safety for the patron? Is it the tenant or is it the landlord?
It would be the agent, because his or her name would be on the alcohol license.
So they're responsible to supervise and make sure that the property is safe for patrons to come.
At their establishment, yes.
And based on your knowledge about the property, who's the agent on the alcohol license?
The agent on the alcohol license is Jabel Daffy.
Okay, and do you know Mr. Daffy?
Not personally, no.
Have you had any run-ins with Mr. Daffy in the past?
Not to my knowledge.
Were you aware that Mr. Daffy at some point owned or operated an establishment called Encore Hookah Lounge on Marietta Street here in Atlanta, Georgia?
It was, I believe, 320 Lucky Street.
Okay, and so you have knowledge that Mr. Daffy operated the Encore Hookah Lounge at 320 Lucky Street?
Yes.
All right, and to your knowledge, were there violent incidents that occurred on the property at Encore?
Yes.
And were there deaths that occurred at Encore Hookah Lounge?
Yes.
And those were the result of shootings on the property, correct?
Can't say on the property, but in the immediate area, resulting from incidents that have occurred at that location.
Okay, and because of the ongoing incidents at that location, the city of Atlanta brought an injunction similar to what we're here today for, correct?
That's correct.
All right, and one of the concerns in that case was from the Georgia Aquarium, correct?
That's correct.
And the CEO of the Georgia Aquarium was concerned about their exhibits being shot up, correct?
Yes.
And as a result of that injunction, Encore was shut down, correct?
Yes.
Lieutenant Carter, going back to May 12th at 11:45, do you know the agents of the decedents?
I'm not sure of the question.
Were they the decedents? who died tragically in the shooting, did you uncover how old they were?
I spoke to investigator Francis. I believe the male that was deceased inside the location was 20 years old.
Okay. And would that be a violation for 1145 had 1145 been correctly classified as a nightclub?
If it was correct, if it was classified as a nightclub and somebody under 21 was inside, not an employee, yes, it would be a violation.
Going back to the audit report, Lieutenant Carter. If the auditor indicated that the alcohol sales exceeded the food sales, would you agree that 1145 would not be in compliance?
Yes, I would agree with that.
How many officers do you employ in license and permit?
At this time, we have one officer assigned to license and permits. We have four investigators, and we have two recaptured sergeants that are acting as investigators, and two sergeants, and then one lieutenant as far as sworn personnel.
Do you have the manpower to constantly go out and do compliance checks on restaurants or nightclubs such as 1145?
As far as checking every single establishment, I believe we renewed, I believe, over 1,800 alcohol licenses for the renewal season for 2024. And we don't have enough sworn personnel to do a compliance check at every single establishment during that calendar year now.
So you would agree that you don't have sworn personnel to do compliance checks over and over for a repeat offender or a bad actor?
If we have a repeat offender, a bad actor, we would then assign it and investigate the location. But as far as like if we go there and during the short encounter they're there, if there's nothing that gets brought to our attention, then we would not continue to pursue it. When a significant incident occurs, then we start investigating to determine if the business is in fact operating in compliance.
Going back to the Encore situation you just spoke about, Lieutenant, do you recall who the agent was on that alcohol license?
It was Jabril Daphne.
And based on your understanding, Mr. Daffy was the agent on or operated 1145 and Encore at the same time?
Yes, that's my understanding.
Had you ever received complaints from the community about noise?
Yes.
How often would you receive complaints?
Regular. Either they come in from citizens or from the zone. I think the last time I was contacted by Lieutenant Finch about somebody contacted him in reference to noise over there.
And what were the substance of the complaints? I mean, generally.
Just that there's loud music coming from that location. We usually try to refer that back to the zone because we just don't have the staffing to deal with noise complaints throughout the city.
What about traffic, Lieutenant Carter? Have you received complaints from the community about the traffic on Peachtree from 1145?
I know there's been traffic concerns. I can't say if I actually specifically got a complaint about traffic.
Lieutenant Carter, under the code, there is a provision where the mayor can take someone's alcohol license, correct?
Correct.
Has that been effective by the city in the past?
Not since I've been there, no.
Okay, and can you explain to the court why that hasn't been effective?
I can't. But I guess that would be something for the mayor to answer.
I guess my question, Lieutenant Carter, is have you seen instances where someone's alcohol license has been revoked?
Yes,
And have you seen instances after a license has been revoked, that license holder, former license holder, would appeal that revocation?
the two alcohol licenses that got revoked, I believe there was no appeal that was filed,
Okay.
to my knowledge.
Okay, is there, we're going back to a due cause final determination. Are those subject to appeal?
Yes,
All right, and have you seen instances where a due cause determination has been appealed?
yes.
And does that happen often?
I would probably say yes. I can name at least three off the top of my head where there has been appeals.
Okay, and can you describe what that process has been like for the city of Atlanta?
If the agent challenges the mayor's findings of suspension fine, they do have a right to appeal to Fulton County Superior Court. And I have heard that they've also, if they don't like the findings from Fulton County Superior Court, then they'll appeal to the Georgia Court of Appeals, and then if they don't like the findings there, they can appeal it to the Georgia Supreme Court.
And during that process of the appeals, the license is still valid and they can still operate, correct?
Yes, they're allowed to operate while the appeal is still pending.
And this has posed a problem with licensing permits or the city of Atlanta in terms of shutting down that behavior by license holders, correct?
That's correct.
Nothing further this time.
Cross-examination.
I could do it, let's do it now. This will probably it'll be a lengthy cross, but we can either do it now or after a break. I'm fine with it one now. If you want to power this.
Okay, is this a good time to break for lunch, or do you want to go ahead and finish up with this witness?
Yeah, I'm fine.
Yeah, I think we can power through.
Okay, great. You okay? Would you like a bottle of water? Actually, you know what, I have to step off the bench 1 second so let's take a comfort break and then we'll finish this witness, like 5 minutes. I saw your face.
Okay, that's a line.
I'm gonna put the motion. You put the law on the motion. Let me ask you a question. Sure. Exhibit 1, has that been previously entered? It wasn't tendered.
Okay, I'll make sure.
Okay.
How you doing?
Thank you.
Good to see you.
I do okay?
Yeah.
I did all those percentages.
Yeah.
I looked at
Oh,
it.
but we cleaned it up because you go with the auditor, you just go and rely on what the auditor said, and he had previously testified. And if it exceeded that, you could.
Yeah, I was trying to go mostly off of memory, so.
Yeah.
But it answered a lot of questions about why we had to have due calls. Now we got a due call, so that goes up, that whole thing about we had to get, you guys hadn't been complaining so it must not be too bad, just, folks y'all have to come.
Usually, we got so many things, and if it's something, unless it's something obvious,
Yeah.
then, but when like something like this,
It's obvious.
it's obvious, and yeah, we need to like look at it. Like Goodfellas, or Deja Vu, or like Lucky Street, Brooklyn Kitchen is, you know, because it takes a lot of time, because then you gotta do undercover work, and, you know, you gotta dedicate somebody to look through all the incident reports, body cam videos. So it's a real, like, deep dive, and like, it's our case file, like, that. About the renewals, yeah. So, but yeah, no, it's, I've been reading. I've been reading like the last 2 days, just trying to be ready.
Appreciate you.
So that sounded okay?
Yeah. That sounded great. And I'm going to go to the restroom.
Because I can't tell if it's
Sounds like they're gonna power through, which means this might not be done until 3 o'clock.
yeah, beat me up, I'll just no hard feelings.
Right now, I have to. This has been my make card I've been reporting on being raw, so I have my second card in here, this is my mark. So this has been reporting,
Oh, so that still has everything up to now.
Yes, Thompson.
Could I take that card down right now and copy it?
Just throw it in the bullpen.
let me, let's see, I don't know how soon they're gonna be coming back. Do you have your computer with you, or is that all?
I thought they were gonna break for lunch.
Okay. Well, I should be, as long as I have my rods on here, we should be okay. I can let you borrow it, or you guys can share my proxy.
I shouldn't be here.
I don't care.
Okay. Because this is my raws, and I only have 2 cards. This second one has been the proxy one.
Now, if I bring you another card, is that help you?
That'd be fantastic. if you
I have
could.
another card. You want me to get it?
Yeah, that'd be fantastic.
Go get my laptop and just quickly get that stuff.
That'd be fantastic, yeah. Because I don't know when they're gonna come back and.
All right, let me give you another card, please. And then.
Yeah, but there are other businesses, so we need to manage the common areas. It is not the parking lot of 11:45.
You're staying through the course of this.
It's a mall.
Yeah, I'm the pool camera.
So if it was just 11:45, we probably wouldn't be managing the parking lot. But we have another 4 or 5 businesses there.
Do I have time to make a quick phone call, or
You
should I
have
wait?
time to go get what?
Make a quick call, or should I wait?
You have time, just step out real quick.
Court come to order, remain seated.
Really quick on the record, I forgot to, move P1 in the evidence.
Okay,
We
any
motion.
objection to that?
No.
It's admitted.
Thank you, Your Honor.
How many more witnesses do you anticipate calling?
Maybe one, but this may be our last one, I'm not sure.
Okay, and then did you decide whether you're bringing a sub?
Yeah, and that's just one
Okay,
witness.
is that person in progress, en route?
She's here, she's here.
Okay, great. And what about you? Are you
Also
calling?
have one witness.
One, okay. All right, we'll get this wrapped up. Thanks. Would you want to roll over now?
Yes, ma'am.
Okay. That's what it's for, so. We've kept you on the stand for a while.
How you doing, Lieutenant Cotter?
Good. Thank you. Are we-
Doing well, doing well. So, earlier you testified, when the city asked you about the difference between a club and a restaurant. One of the things you mentioned, is that, all restaurants do not have live entertainment, correct?
That's correct.
And in regard to that, how does a business get live entertainment? What's the process? What business are qualified to have live entertainment?
They would have to submit what type of entertainment they plan on providing in their initial application, and then they would have to submit a survey to make sure they meet the distance requirements.
Okay. Is there any distance? There's not any difference in the distance requirements between a restaurant with live entertainment and the distance requirements from a nightclub, is there?
My understanding is no. I think it still has to be a survey.
Yeah, it still has to be a survey that shows that there are those distance requirements. So is it accurate to say a restaurant with live entertainment is required to have a distance survey, whereas a restaurant that does not have live entertainment may not be required?
That's correct. If they don't have live entertainment, they wouldn't be required to submit a survey.
So that means that at some point, either 1145 or a previous operator of that location, at some point, somebody at that address where 1145 is operating, presumably either had a survey submitted to the city at some point in history, correct?
But both of them would probably have to submit a survey. But I have the copy of the mayor's signature page for the previous agent, which was application by the Glass Atlanta LLC, doing business as Frank Ski, Frank Rodriguez, license request to operate a restaurant with liquor, beer, and wine consumed on premises, customer dancing, live entertainment at 2110 Peachtree Road.
Okay, thank you. So essentially, as far as the alcohol code is concerned, if 1145 has a live entertainment license, they're a restaurant with a live entertainment license, the only difference between a restaurant and a nightclub is just the way they operate. Since they have a survey, the only difference between a restaurant and live entertainment, or the primary difference, is the way they operate. And when I say the way they operate, I'm including hours of operation, as you mentioned earlier, and the food and alcohol sales, correct?
The food, alcohol sales, the operating, like a nightclub can't be open on Sundays, or a restaurant can be open on Sundays. A nightclub has to have patrons out of the establishment by a certain, I believe, 30 minutes after they give last call, or but alcohol sales must be deceased, which is at 2:30, which is hours of operation. Then all the patrons have to be out by 3.
And I'm glad you mentioned that about the hours of operation. You've never had any issues with hours of operation for 1145 in your history, have you?
No.
As far as them operating too late?
No.
And the witnesses earlier testified, a common theme the city is presenting is they've asked everybody what they thought 1145 was a nightclub or a club, and you know, you're the first person to say it was hard to say, but you're the one that's an expert in this area, so I agree. You spoke about the fact that 1145 represented they only open 5 days a week, but let's go through a couple other things that I've heard people mention. You just tell me if any of these things are illegal or only apply to nightclubs. if a business has booths, are restaurants allowed to have booths? I mean, is there anything preventing restaurants and alcohol code from having booths inside of their establishment?
Not aware of any, but I believe the nightclub definition is like booths of 100 persons.
Is there anything in the alcohol ordinance that prevents restaurants from charging for entry?
No.
Is there anything in the alcohol ordinance that prevents restaurants with live entertainment from having DJs?
If they have live entertainment, yes, they're allowed to have a DJ.
Is there anything in the alcohol ordinance that prevents restaurants from charging for people to have sections?
No.
Okay, thank you. Now, you've already gone through the due cause process. I'm gonna get into that a little bit later. But in the meantime, you mentioned that you've done a lot of compliance checks in the area. What do you mean by the area when you said that earlier in the record?
We've done compliance checks with all the different businesses in that area, up and down Bennett Street, Tula, Peachtree.
Can you name a few of the businesses that you have knowledge about?
Golly Garden, which I believe is no longer in business, but there's another business there now. You have Zari Cafe, Smoke City, obviously 1145.
Have you heard of the business named Taranga? Heard that name?
I've heard that name.
Tell me more about this Zari. Oh no, let me back up. You mentioned earlier that you cited some other businesses. You haven't cited 1145, but which businesses do you recall citing on that street?
We executed 2 search warrants at Golly Garden, which I believe was either 24 or 25 Bennett. Zari Cafe received a citation for underage. The employee served an underage person. And Smoke City at the time, which I believe was 22 Bennett, the individual was arrested for selling alcohol without a license.
Do you remember any shootings at Zari, or any causes for any shootings at Zari?
Yes.
Do you remember any details about that shooting? Or did it happen inside of Zari?
I believe it happened inside of Zari. If my recollection is it happened inside of Zari by the bathrooms.
By the bathrooms. And did you bring any due causes for any of the incidents you mentioned for Zari or?
Yes.
Or, how many due causes against Zari?
2.
2 separate due cause actions. And do you remember what the, let me see, how many against the Smoke City? Is that what you said?
We haven't brought anything against Smoke City.
Okay. And then, have you brought any other due causes against any other business on Bennett Street that you recall?
We were going to bring a due cause for denial of application for Golly Garden, but they withdrew their application.
So that's at least 3 due causes that you can remember on Bennett Street for businesses under 1145. We're not, so are there any more due causes you can think about for Bennett Street that you've been a part of?
2101 Tula, which was level 5 lounge.
So, so it appears there's been a lot of activity on Bennett Street. So earlier you talked about how you've done compliance checks in that area. So how many compliance checks would you estimate you've done for 1145 or in the area of Bennett Street on the estimation? You don't have to be exact.
Approximately, I'd probably say between 40 to 50. I can get you the exact number.
Between 40 to 50 compliance checks. You're saying out of those 40 to 50 compliance checks, you never found any reason to cite 1145. Is that correct?
They were cited once, but we had to void the citation because the mayor's executive order that'll give an extended time for businesses, and we were unaware of that, so the citation was voided.
When you talk about the mayor's executive order, you're referring to during COVID when there was an issue with some of the online renewals of alcohol licenses throughout the city, and the mayor issued an executive order suspending enforcement of the alcohol ordinance because of COVID related, or I want to say COVID and online related issues. Is that correct?
For that particular instance, it was the business license that they were allowed the, period, a grace period, which we weren't aware of at the time, but once we were made aware of it, we avoided the citation because they weren't in violation. And to answer your earlier question, we've done approximately 47 compliance checks in that area between July of 2019 to May 13th of 2024.
So has anybody reached out to you prior to May of 2024? Has anybody reached out to you about any violent incidents at 1145? Because I believe you, correct me if I'm wrong, I believe your testimony is that that was the first incident that you were aware of at 1145. The other ones you said were around the area.
I have been made aware of shootings in that particular area. I believe in 2020 there was a shooting, I believe, at the intersection of Peachtree and Bennett. There was another shooting in the area of 49 Bennett. There was a shooting at Zari Cafe. So there has been shootings in that area that I've been made aware of.
After being made aware of them, you did not take any action against 1145. Is there a reason why you didn't take any action against 1145 for any of those other shootings?
Since one shooting that I know of happened on the street, it would be very difficult to try to tie that to that particular business.
And because that shooting happened outside and it was outside of the business on the street, that's the reason why you didn't pursue anything against the business, correct?
Yes.
But you were aware of it at that time.
Yes, I was.
I have a question. Can you explain the process when it comes to restaurants operating 6 days a week? How do you enforce that? How do you stay on top of that? How does license permits deal with that issue of the days of operation?
Well, we look and see the advertisement. That's probably the easiest way. We look and see what they're advertising for it. In one case, my sergeant just happened to be working his part-time job in that particular area and noticed while working that part-time job that that particular business was not open 6 days a week. We've also asked the zones for assistance by having either the day watch beat officer, evening watch beat officer, morning watch beat officer go by that location and make a notation whether or not the business was open.
Are you aware that there's that a lot of are you aware that there's a number of businesses in the city of Atlanta that hold themselves out as restaurants that do not have live entertainment, that do not charge a cover at the door, that do not have booths, that do not open 6 days a week? Are you aware of that? Or?
If I'm aware of it, we'll do a compliance check and either write a citation or advise them that they're in violation, depending on how egregious the violation is.
So if the restaurant, like let's say, I don't know if you know the restaurant Sushi Hawakawa, like they represent, as you say online, they're open 6 to 10 Wednesday through Saturday. If somebody gave you knowledge that they're open less than 5 days a week, would you go out there and cite them as well for?
Well, it also depends, does this particular business have an alcohol license? Because if they don't have an alcohol license, then they wouldn't be bound by the 6 days a week.
Do you have knowledge of Sushi Hawakawa, or do you know about that?
I have no
restaurant?
knowledge.
Do you have knowledge of the restaurant Atlas on West Spaces Ferry?
I have no
That's
knowledge.
Open Tuesday through Saturday from 5 to 10? Earlier you were speaking about the process, the city asked you about the process, the alcohol license process, and what's required for a nightclub and what's required for a restaurant. I think you're correct in that health permit and grease trap permits required. But from a licensing perspective, for a restaurant and for a nightclub and for a bar, for all on-premise consumption applications with the city of Atlanta, isn't it true that all of them are required to get a building, fire, and health approval?
Yes, that's correct.
So that means that even if you're a bar, or even if you're a nightclub, no matter what your designation is, you for alcohol license purposes, you all have the same permits.
That's correct. Fire, building, health.
All right. I'm gonna go into the alcohol code a little bit with you. Now, are you familiar with section 109 or 10109 procedures under chapter 10 of the alcohol code?
Yes, that's the due cause section.
Actually, let me go to a different section first. Before I get into what constitutes due cause, are you aware of 109.1, which is the penalties for due cause? So, as you know, there's progressive penalty. Are you aware of the progressive penalties for city of Atlanta alcohol license violations?
I am.
All right, so you're also aware that do you know what the minimum and maximum fines and suspensions are for a first violation, a second and third?
I do.
Can you tell the court what they are?
Well, it would depend if it's whether or not it's a pouring establishment or a non-pouring. Do you want both or just?
Yeah, how about just for pouring on premise?
All right, pouring on premises, first violation is a minimum of 5 days up to 180 days or revocation of the license and a $2,500 fine. Second violation is 30 days up to 180 days or revocation of the license, and the third offense is a revocation of the license.
That's very good. That's very good. That's absolutely correct. As you mentioned, for the first violation, minimum is 5 days, and goes up to license revocation. Correct?
Correct.
And you said it for the second one, minimum 30 up to license revocation. And the third, does the city or the mayor have any discretion, from your understanding, to do anything besides revoke the license on a third violation?
My understanding is no, because of the code.
Thank you. So now I'm gonna get to the procedures of and what constitutes. Well, can you tell the court what a due cause is, or what is due cause?
Due cause is a violation of a violation of an ordinance or operating code that allows the city to do an administrative hearing as to whether or not the business was in violation, which suspension, fine, or revocation of the alcohol license may occur.
Isn't it true that another option under the procedures is the refusal to renew a license as well?
Yes.
So that's found in 109A. So what I'm going to do is I'm going to go through a few of these with you. Under 109, under section 10, 109 procedures, subsection 7, it says the selling or serving of alcoholic beverage to any person, the licensee or licensees or employee should have known to be in a state of intoxication. In the city's complaint, although they didn't proffer any evidence here, I saw some allegations of people who may have been drunk leaving 11:45. Have you cited 11:45, or do you have knowledge, or have you given them any citations under that code section at all?
Under that particular code
Yes.
section? No.
Okay. The city also, under subsection 8, 10-109.8, the failure to comply with any and all federal, state, or municipal tax laws and regulations applicable to the operation of establishments licensed to sell alcoholic beverages. Have you issued any citations related to that article?
No, but we're currently investigating based on Mr. Gaines's information provided to me.
So you could issue a citation regarding that today if you wanted to, correct? Or soon, you could, correct?
I could, but I'd like to, usually with those type of ordinances, I like to consult with the law department prior to taking any action.
Understood. There's another section you mentioned earlier. I think you said failure to supervise. The exact language of the code, subsection 10 of 109, says failure by the licensee to adequately supervise and monitor the conduct of employees, patrons, and others on the licensed premises, or any property owned or leased by the licensee, including but not limited to parking lots and parking areas, or any parking lots or areas which may be lawfully used by patrons of the licensed establishment in order to protect the safety and well-being of the general public and those utilizing the premises. Now we heard testimony about incidents that happened in the area around the parking lot, but you've never taken a due cause, you never initiated a due cause under that code section for 11:45 yet, have you?
No, but we're currently investigating.
And when you say you're currently investigating, you're investigating based on the May 12th incident, correct?
That's correct.
Not on any other prior incidents that the city has talked about today that happened in parking lots or areas because you didn't believe you had enough evidence to bring forward a charge against the establishment under this code section, correct?
That's correct.
All right. Another one under this section, number 15, says the failure of a licensee whose licensed premises directly abuts a public street directly to maintain all property outside the lot and property line and inside the curb line upon the public street, including any sidewalk. Said duty to maintain the above designed property must be accomplished within a reasonable time after the close of each day. Maintain, as used in the subsection, shall mean keep the specified area free of bottles, cups, trash, and other debris within a reasonable time, as used in the subsection, shall mean within 4 hours of the close of business. Now, you weren't here, but some witnesses testified about there potentially being trash and debris left out around the location. Have you ever issued a citation under this subsection, or have you cited the business under this subsection for failure to maintain the property outside of 1145?
No, I was never advised that there was
Yeah.
trash or anything like that.
Thank you. There's another subsection of the same code. The violation by either the owner, the licensee, the management, an employee, an independent contractor, or anyone acting as an agent for or on behalf of any establishment licensed to sell alcohol of the city's noise ordinance, found in Chapter 74 of the City of Atlanta's Code of Ordinances, or Section 10-60A43, if such violation is reasonably related to the operation of the licensed establishment, and the owner of the licensee knew or should have known of the violation of the noise ordinance. Once again, have you ever issued a citation for 1145 under this subsection before?
I have not.
No. So you never found the need. You never found the need to because you not believe that they were guilty of that code section. You didn't have information related to such, correct?
I object, Your Honor, to the fact that he is not one to opine as to whether someone is guilty under any code section. That's within the province of the court.
That is
Or the
ultimate issue,
administrative.
but you can ask the question differently.
Have you been advised? One, you haven't already. You already testified. You haven't cited anybody under that code section. Have you been advised to cite anybody under the code section, or have you been? Has that?
Can you ask that, not calling for hearsay?
Yeah. I'll leave that one there.
Okay.
Now, there's another one, subsection, this in 10109H, it talks about property owners of licensed premises. Now, it says they will be responsible to the reasonable extent for unlawful activity which occurs in their premises on a regular basis, such that the property owner knows or should have known that such unlawful activity was taking place in licensed premises. If it appears that such activity was encouraged, or if it appears that the property owner could have prevented such activity, in addition to being authorized to deny, revoke, and refuse to renew the license, the mayor should be authorized to deny the issuance of any license under this division at that location for a period of up to 2 years from the occurrence of such unlawful activity. And such property shall also lose its permitted and non-conforming use in the same period. Have you ever cited 1145 or initiated due cause about that location?
No, I think it also has to say you have to also put the owner on notice
Yeah.
in that ordinance.
Have you ever put the owner on notice about any issues related to illegal activity?
No.
You haven't? And one more thing, out of all the questions that I asked about, out of all the sections, have you ever filed a due cause for failing to renew the alcohol license for any of these code sections?
No.
So correct me if I'm wrong, but the city's renewed the alcohol license for this establishment since it was originally permitted every single year, correct?
That's correct.
Now lastly, you testified earlier about the process when the mayor gets a due cause, and you guys and the applicant goes before the board, and how applicants can appeal any decision. Were you aware of subsection K in section 10? In section 109, 10-109, subsection K, that allows the mayor to suspend a license without a hearing. Were you aware of that section?
I'm aware of that section.
So, under that section, it talks about how the mayor can, it says, the mayor can deny an application or deny a transfer of ownership or revoke, suspend, refuse to renew a license or permit, or impose a fine, I'm sorry, let me back up. Right. Sorry, subsection G, my apology. It says that the mayor may, upon the finding of due cause, deny, revoke, suspend, or refuse to renew any license upon a determination that public convenience and advantage will not be promoted by approval of the applicant's application. In making such determination, the mayor may consider the general welfare and safety of the community, noise, parking, and traffic, with reasonable consideration being given to the character of the area and its peculiar suitability to proposed uses and the stability of the neighborhood as it may be impacted by the proposed licensed premises. So when it says that, one second. So once again, you haven't brought any due causes, or you're not aware of any due causes that were exercised under that subsection either, correct? For 1145, sorry.
No.
One second. Make sure I have everything. Isn't it correct that you requested an audit of 1145's revenue from the Department of Revenue?
I did.
Do you recall around what day that was?
It was May 12th.
Was it May 12th or May 13th? You think it was 12th?
I have an email that says May 12th.
Oh, it was May 12th. Was that the date of the shooting, if I'm not mistaken?
Yes, I have the email. It's May 12th, about 4:52 a.m. I made that request after I came back from the crime scene.
So is it safe to say that that incident that occurred in May, I guess in your words, you said that you don't go to locations, or I don't want to say you didn't go to locations, but you said compliance checks are done once you're made aware of an issue, or?
I don't believe I said it that way. I said we regularly do compliance checks, and if we see something that requires a follow-up investigation, then we'll investigate it. But if it's something that is not an immediate or not a violation, then no. It's just we have over 1,800 alcohol licenses in the city. So any particular event would generate a investigation. Any type of complaint would generate an investigation. But if we just do a routine, go to the location and we don't see anything that causes alarm, then no.
Yes, your testimony is that you did receive complaints about the area in the past, correct?
Yes,
And you follows up with multiple, in your words, 40 to 50 compliance checks, correct?
yes, which some of them led to search warrants, arrests, citations.
But none of them led to search warrants, arrests, or citations for 1145.
That's correct.
And this is over the past, did you say since 2019? Is that what you said?
July of 2019.
So over the last 4 years, you've been to that area around 40 to 50 times, not cite anybody but 1145. To your knowledge, are any of the other businesses that you've cited, are they currently subject to be nuisance actions to your knowledge?
To my knowledge, no.
And your testimony was that, to your knowledge, the licenses that were revoked recently that you have knowledge of, those are not under appeal, to your knowledge, that you're aware of.
To my aware of, no.
So,
Hi, Ben Cutter. I represent Venice Street Properties, who's the landlord, not only for 1145, but the business around there. They include hairdressers, salons, and are you familiar with the area?
Yes, I'm familiar.
Okay, so when you're talking about being there 47 times in around Bennett area, are you talking specifically that Bennett Mall, or because there are so many business around, what are you talking about specifically?
All the businesses in that general area of the Peachtree, Bennett, Tula.
Okay, so not just that mall
No.
where the 1145 is located, correct?
In that general area, yeah, 1145, Bennett, Tula, all the different businesses over there, yes.
Okay, so when you go there to do inspections or you have complaints, they could be about, what do you say? You say noise, trash, violent?
If it's trash, we usually refer that to Atlanta Police Code Enforcement. The noise, we usually try to have the zones address the noise. So if a citation is written, then we will follow up with a due cause based on the citation. We primarily focus on investigations such as after-hour alcohol sales or minors, being sold alcohol to minors, or not unlicensed establishment is the bulk of our investigations.
Okay, so there are about, just on that mall on Bennett Street, there are about 2 other establishments, correct? Very close to 1145. Are you familiar with them?
As far as selling alcohol,
Yes.
I'm aware of,
You're aware of those establishments?
I believe there's 2 or 3 over there, yes.
Okay, do you remember their names?
One is Zari Cafe.
Okay,
I believe the other location, it used to be called Smoke City, I don't know what they're called now, 22 Bennett. And then they just opened up another business, I believe, on Bennett.
okay, but you don't know their names?
I don't know
or
the name off the top of my
if
head.
Okay, now with Zeri Cafe, you said there was a violent occurrence there. Do you know what happened?
Somebody got shot inside near the bathrooms.
Okay, but you don't know the specifics?
I don't, not off the top of my head, no.
Was anybody arrested that day, do you know?
I don't know.
Okay. Was a citation issued?
The due cause was done, but no citations I'm aware of were issued.
Okay. And what about Live 5 Lounge? You say there was a shooting there, you just mentioned that place.
There were 3 shootings, or 2 to 3 shootings in the parking lot.
Okay, do you remember if this business is still functioning?
I believe they're closed now.
Okay. Now, did you ever notify the landlord, or actually got in contact with Venice Street Properties when you go and do a due cause?
No.
That's all I have. Redirect?
Yes. Lieutenant Carter, you went over the code section regarding due cause with Mr. Bailey a minute ago, correct?
That's correct.
And those progressive penalties that they went over in terms of what the board can, let me ask you a question, Lieutenant Carter. The due cause hearings, those go before a court or a board? Who do those go in front of?
They go before the License Review Board.
Okay, and the penalties that come out of those due cause hearings, whatever progressive penalties y'all went over, those are all subject to appeal, correct?
That's correct.
And that's kind of earlier that you testified that usually the appeals process takes a long time, correct?
It can, yes.
And during that time of the appeals process, the establishments are allowed to operate, correct?
That's correct.
All right. And also from a due cause matter, the only penalty is whether they'll have their alcohol license taken, correct?
That's correct.
And so theoretically, an establishment can go through due cause and have their license revoked, but they can still operate without an alcohol license, correct?
That's correct. They can still operate as a restaurant.
And so the due cause does not shut down the business, correct?
No, it does not.
Okay. Now, going back to one of the other things that you testified a minute ago about failure to supervise. And you testified that an agent is required to supervise the parking areas, correct?
Yes, parking areas that they control.
To make it safe.
That's correct.
And so if they don't, what happens if they don't control any parking areas?
If we can show that they, control that by reviewing the application, and it shows that they control that particular parking area and it's frequented by their patrons, then we can bring a due cause against the business for failure to supervise.
Okay, what happens in situations where an agent doesn't have the authority to supervise or control the parking lot?
We would have to consult with the law department to see what their legal opinion is as to whether or not it meets the criteria for failure to supervise.
Okay, so if an agent doesn't control the parking lot at all, would they automatically be in violation of failure to supervise?
No.
But they would, you said you would go to the law department to determine whether they should be deemed to have failed to supervise.
We would have discussions based on our findings, and we would go to them with either a recommendation that this is what we believe, and then they would say whether or not it meets the legal justification. There have been times where they've said, no, you don't have enough to proceed.
Okay. In regard to, you just testified a moment ago that you know of other establishments down Main Street, including Zari Cafe, correct?
That's correct.
And you just spoke of an incident where someone was shot inside the Zari Cafe, correct?
That's correct.
With that incident, were multiple persons shot in Zari Cafe?
I believe, if my memory is correct, I believe this happened in 2020 or 2021. I believe one person was shot.
Okay, and did that person succumb to their injuries?
I don't believe so.
So they survived?
I believe so, yes.
So no one in Zari Cafe was murdered inside?
That's my recollection now.
And so, in your opinion, out of all the stuff that goes on Bennett Street, is 1145 kind of the epicenter of the criminal activity that's going on? In your opinion?
I can't determine that. It's hard to, based on all the business in the area and they all share the similar parking.
Okay. Have you received more complaints about 1145 out of all the establishments over there?
I would probably say yes.
Now, going back, I know Mr. Bailey asked you about whether you cited 1145 for junk or trash or debris. Do you remember that?
I remember the question, yes.
Okay, and you as lieutenant over license and permit, you only cite folks under the alcohol code under chapter 10, correct?
Chapter 10, Chapter 30, or other permits that are required that we process.
Sure. And so, but you don't issue citations for junk, trash, and debris, though?
No, well, not since I've been there. I don't think we've ever issued a citation for trash or debris.
Okay. And let me ask you a question about the code, the alcohol code. Are establishments allowed to sell alcohol by the bottle under the code?
The only thing I was able to find on that ordinance was each business is supposed to do tax by the drink, which I'd be very difficult to do if they're selling a bottle.
And I know you just stated a second ago, in chapter 30 under the code, is that where you would find the requirements for licenses for restaurants and nightclubs?
Chapter 30?
Yeah, chapter 30.
As far as like business license, yes.
Okay. And so I'm just going to show you this. This is This is, again, may I approach your?
Yes.
This is a petitioner's 19, I guess 19A judge, or, because I know we did 19 was chapter 10, that is chapter 30, so I think we could call it 19 or 19A.
Whatever you prefer, is fine.
Okay, I'm gonna mark that as petitioner's 19A. Can
Okay.
you describe for the court what that is?
Appears to be a certified copy of chapter 30 from the office of the municipal clerk.
Okay, and your testimony today about how restaurants and clubs, nightclubs would be licensed as a business, that all derives out of that chapter?
Yes.
Okay. We move to admit 19A in the evidence, Judge.
Any objections? It's amended.
Nothing further.
Cross?
Just real quickly, Mr. Dixon just touched on the progressive penalties that we were talking about earlier. And just to be clear, isn't it true that when it says first violation, can you explain to the court what they mean? Let's say the establishment has 4 different violations. How would you bring that before the License Review Board if they had 4 different violations?
What the license review board has been doing is one incident, like 4 counts, but one incident, so it only counts once.
Correct, but when you say counts 1, isn't it correct that the License Review Board would count it as, if it's 4 instances, it'd be 4 first violations, correct?
It would be a first violation, but it'd be four counts.
4 counts, so
Yes.
in your history, for each count, doesn't the law apply to each count? What I mean by that is if you have 4 counts, then the minimum suspension for each count is 5 days suspension for each count, correct? So if you get cited for 4 things, it'd be 4 times 5, so 20 days minimum, correct?
That's a possibility, but also there's some times where they just go with the one incident and then give it whatever penalty that they decide they feel appropriate.
Okay. And real quick. So one thing I want to brush up a little quicker, one more time. Under subsection F of 109F, it says for due cause, if a violation of this chapter occurs which results in an emergency situation in which the continued operation of the premises by the licensee endangers the health, welfare, or safety of the public, the mayor or the mayor's designee may suspend any license. Any such suspension may be made effective immediately and shall remain in force until the next regular or called meeting of the License Review Board. So I want you to get some context for this because it says that if the mayor can suspend a license immediately, and that suspension remains in effect until the next License Review Board, can you tell the court roughly how much time it takes for a License Review Board to be placed on a License Review Board agenda?
Not sure I understand your question.
So-
The license review board meets twice a month.
Twice a month. So if the mayor were to utilize this section F and suspend a license immediately, how fast could that suspension get before the License Review Board in your opinion, or within your knowledge of?
Within my knowledge, I mean, the mayor could, or mayor's office could reach out to the board chair and say, we need to organize a meeting, or wait till the next regularly scheduled license review board hearing. If I can give you an example, if the license was suspended today, we have, I believe, the next LRB hearing is this coming Tuesday.
But then how much notice is required for due cause actions under the code, to your knowledge?
I believe it's 5 business days.
5 business days. So that would mean that the mayor would have to make a decision. If the license was suspended immediately, the fastest that an application can get to the License Review Board would be 5 days after giving notice to the applicant. Is that correct?
That's correct.
And do you know how much time the mayor has to act on an application that's been before the License Review Board?
For a due cause or
For any application?
For any application.
Yes.
I believe the mayor has 60 days.
And how about for due cause?
For far as to take action on a due cause, the only statute that I'm aware of as far as if the mayor does not sign off on a due cause, then at the end of his term, then the decision of the LRB is final.
So let's go into that decision of LRB is final. So if the mayor were to suspend the license, and then the license review board made a recommendation, that recommendation is not final until the mayor signs after the recommendation, correct?
That's correct. I also left out one other thing. Once the mayor signs off on the due cause, we didn't have 14 days to serve the business, but the suspension will take effect.
So theoretically, in a situation that results in an emergency, in which the continued operation of the premises by a licensee endangers the health, welfare, and safety of the public, the mayor could suspend the license, made effective immediately, and the only thing that you know that would force the mayor to make a ruling on the due cause is if his term ended. And then at that time, the recommendation of the board will become final, correct?
That's correct. If the mayor has not signed off on the due cause, then yes, the license, the board's decision would be the decision.
That's all.
Anything for Bennett Street? Any redirect?
Lieutenant Carter, the subsection that Mr. Bailey just brought up, in your experience, has that subsection ever been revoked?
Which subsection? I believe
About the
4.2.
mayor, taking the license summarily without a hearing, due to, safety and welfare.
No,
It's never been invoked.
no. To my knowledge, no.
And then the way that subsection works, to your knowledge, is it would only be suspended until the LRB had a time to review it, correct?
Correct.
And whatever decision or recommendation the LRB comes with, that is appealable, correct?
The mayor would take it under advisement, although the LRB is pretty much a recommendation.
Sure, but what I'm saying is whatever the recommendation that comes out the LRB, that is appealable.
No, when the mayor's decision is appealable.
Right.
The
So-
LRB, the mayor could either, go with the board's decision or refer it back to the board for additional questions.
Okay.
Or the mayor can just simply not go with the board's recommendation and
And so that final, I guess my question, Lieutenant Carter, is that final determination is appealable?
the final determination by the mayor is appealable, yes.
Okay. And then, also, whatever that decision from the mayor, again, that only deals with the alcohol license. It doesn't deal with the ability for the business to be shut down, correct?
No, it does not.
That's all I have.
Okay, any recross because of that? Okay. You're excused. Thank you. Any other witnesses?
No, we don't have any further witnesses.
So petitioners rest?
Petitioners will issue.
Okay, do you need a minute to record? Okay, I'm gonna step off the bench. Is your witness waiting in the witness stand? Okay. All right, I don't care what order you go in, it's up to you guys. Do you need? Okay. Okay. How much break? How much break would you guys like before we start with the defendant's case?
It's up to you, Judge. I know you haven't had lunch, so we defer to you.
Is half an hour okay?
That's fine.
Is that enough time for you to get organized?
Yes.
Okay. If you're ready earlier, I'll just sit back there, so just holler if you want me to. I know Matt Corporal for the break.
Yeah, you're good to go.
Thank you so much. All right. Thank you so much.
just, flag it down.
Did you need Judge Carousel or something? Okay.
Sure.
Yeah, okay.
So, this will something take it off. You can issue that.
Yeah, I'm thinking, yes, yeah, I mean, I just don't need a lot, just a little. Okay, come on. Cause it look like she gonna try to finish this up. It's gonna be, I don't know, yeah, we should be able to finish up.
Have you talked to
Only
the
two.
prosecutor?
There's some cases that sign up with. So with it being on non-complex, it's, it's just kind of like a catch-all cornucopia.
Yeah, that's kind of how they work.
Yeah, nobody's necessarily assigned to the case.
Okay, I think I gave them, have you talked to Thomas White? He's the supervisor in the ADA's office
Okay.
for non-complex. It's,
Alright.
his last name is
Going up. Yeah, I was hoping I could catch Judge Brown, so, is it W-H-Y-T-E?
It's
Appreciate the help, by the way.
because Judge Carousel's not gonna do anything without a prosecutor.
Got it.
Tom White, W-I-G-H-T.
Okay.
And his phone number in our Outlook system is 404-612-4886.
Perfect.
I believe he supervises non-complex, so he would be in a position to,
So at least be able to make a recommendation.
yeah,
Yeah.
with it being a bench warrant,
It's always.
you're gonna need a prosecutor.
Yeah, but
Unless-
it's like they don't assign these cases to the courtroom, they have magistrates sitting by designation, of course, they don't have the same kind of staff and.
Yeah, and I think now the non-complex are supposed to be in two pretty distinct divisions. I'm not sure if this case, has a,
And honestly, there's not even anything of one odyssey about the case yet, so, I haven't even been able to pull down the documents online, so I have to kind of go down to the clerk's office in person.
let me see if I can, do you have the case number?
You know what, I do not.
Will you remind me how to spell his first name?
So it's a D-J-I-B-R-I-L.
I can tell you from our view of Odyssey, who originally put that arraignment calendar together that
Okay.
he was on.
Okay.
And that person is Giselle, Giselle, Diaz, Diaz.
Okay.
And that person's a litigation manager in non-complex. So I don't know how they divide the work there.
Right.
Non-complex is a mystery to us, just like it is to you
Yeah.
guys. And the phone number for that, her,
Mhm.
I assume, is 404
Okay.
613 1386.
Perfect.
So we
Um,
typically, as presiding, won't handle things that are non-complex without somebody in the non-complex division giving us approval,
Sure.
a special, judge isn't gonna hear anything without an ADA,
Right.
obviously.
Yeah.
But in the event we can't hear something, that person may be able to tell you how it gets on another calendar
Right.
with the properly assigned judge.
Right. Yeah. Understood. Could you give me the case number if you've got it?
Oh, yes. It is 23 SC 191727.
Perfect. All right. Thanks
And
so
what's your
much. Alcee Honore.
All right,
And your name?
Laura Schuster.
Laura. Thanks a lot.
Uh-huh.
Appreciate it.
Hopefully that gives you some leads around here.
Yeah, I mean, we'll see how far we can get it, but at least if I can kind of touch base with someone and we can have a plan, then,
Yeah.
I kind of, my part is done, so.
hallway,
Gotcha.
because the recording's still on.
Oh, it's not.
I have no idea. Walker? I wouldn't tell nobody that. Not that kind of message. Wow.
Court will come to order, remain seated.
Oh, we're missing Bennett Street. While we wait for him, I'm just gonna step off and answer this call and be right back. Or her. You know where she is?
Well, she was downstairs in the cafeteria.
Oh, okay. There's a cafeteria again?
It's very, very,
Oh, you mean
mild version.
the candy bar room?
Yes,
Okay.
candy bar room.
She said the candy bar. Okay, come on, let's get this party started. I'm hungry. But it ain't gonna help it.
Court will come to order, remain seated.
I did too. Oh, when we broke? Oh, maybe I didn't give her. Did I like give you guys 30 minutes before I came back? Did I come back too soon?
No.
No?
I'm sorry.
You're okay, it's fine. I didn't pay enough attention to the clock and I was worried I came back too
Prepare
soon.
the witnesses as well, so we don't have to break up again.
That's great.
Before we get.
Okay, when you're ready, go ahead.
I'll put a blue chair
You
for
can
you.
come up. He'll swear you in, and then you can sit right there.
Yeah, to blue chair, blue chair. You can turn and face me and raise your right hand. Right hand. Do you swear affirm the testimony you give to the court is the truth, the whole truth, so help you?
Yes.
Go ahead and have a seat and enter the mic, state and spell your name for the court.
Brianna Panton, B-R-I-A-N-N-A, last name P-A-N-T-O-N.
Good afternoon, Brianna. Can you tell the court what your current position is with the 1145?
1145, I worked there as a waitress for a couple years.
And the other question, can you also explain to the court your experience in the restaurant industry?
I have experience because I opened up Del Frisco's Grill that they have in Buckhead area. I was one of the people that was there from first brick hitting the ground on up. I've worked with Local Luna. I've worked with Buffalo Wild Wings, doing a lot of stuff with colleges and corporate outreaches, doing a lot of things with learning all the position and training and everything inside there.
Are you familiar, I'm going to approach with what's been marked as Exhibit 1. It's a menu. This has been marked as the finished Exhibit 1. Are you familiar with what this is, what this document is?
Yes.
Can you explain how you're familiar with the document?
The document is the new menu that we're going to have for the restaurant. For I guess the new menu for the restaurant. I guess I couldn't even explain.
Okay. Did you have any involvement in creation of this menu?
Yes, I created the menu.
Can you explain a little further about the creation of the menu?
Okay, so I created the menu, the drink menu, the appetizer, the dining entrees that we have, the desserts for the new experience that we're going to bring to the Buckhead area.
Are you aware of what the new proposed name is for the establishment that's formerly known as 1145?
Yes.
What is that name?
Le Rep.
Can you say it again?
Le Rep.
Le Rep. Can you spell that for the court?
L-E-R-E-B-E.
And how did you become aware of this new name?
During the time that Jabril was out of town, we started working on new concepts for the restaurant.
Okay. Your Honor, I'd like to introduce this exhibit, the finished Exhibit 1 to the record.
Okay. Any objection? Is that still the menu?
Yes.
No objection.
Thank you.
So, are you familiar with the new security company that that the business wants to, the new security company that will be working at 1145 at the business formerly known as 1145?
Yes.
How are you aware, or can you tell the court the name of that company?
Lion Gates.
How did you become aware of Lion Gates, and how do you have knowledge of when they were hired and how the owner of the business 1145 was introduced to Lion Gates?
I actually introduced Lion Gates to Jabril as a establishment that I know that has done other restaurants in the area and other businesses like Icebox. So I just felt like if we could protect them, we could protect, the rest of us. And I was there for the interviewing of them, making sure that they're meeting everything that we need now for the new restaurant.
Okay, so were there any other discussions? Were you a part of any other discussions? Were you a part of any other discussions with the new security group with Mr. Duffy?
Yes.
So you were present when security measures were taken, when discussions about security were taking place?
Yes.
Additionally, I'm going to show what's been marked as, I'm gonna give you a copy of what's been marked as a defense exhibit number 4. I'll describe what you see in that picture.
That is the new metal detectors that was ordered for, the rep.
When were those metal detectors ordered?
The metal detectors was ordered, I would say, June, beginning of June, end of May.
How do you know when they were ordered?
I placed the order.
So you placed the order directly with the company to order those?
Yes.
I'd like to introduce into evidence. So is this an accurate copy of the metal detectors that are currently at the business formerly known as 1145?
Yes.
I'd like to tender this into evidence.
Any objection?
No, Your Honor.
It's admitted.
And now I'm going to provide you with a copy of what's been labeled as Defendant's Exhibit 3. Are you familiar with the document in front of you?
Yes.
How are you familiar with that document?
I wrote it.
You said you wrote it?
Mm-hmm.
And are you familiar with the contents inside of this document?
Yes.
And what is this document? Can you just give the court a summary of what's included in this document and what information you've included, just a short summary?
This document is containing the future plans for the ongoing business of the Rev. It will tell you about the hours of operation. It will let you know our security protocol that we plan on using and how we plan on making this environment great for the patrons coming in.
Okay. Let me see. Is there anything else about the security protocol that is not listed here that you want to include for the court for their knowledge? That you have knowledge of?
No, not at the moment.
That's all.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Penson.
Yes.
My name is Pat Dixon. I represent the city of Atlanta in this case. You say, so your current role now, you work currently for 1145, correct?
Yes.
All right, in that role, you're a waitress, correct?
Yes, I was a waitress for 1145. Now that we're transitioning over to a restaurant, a further restaurant where it's going to be more, I would say a more experienceable dining experience instead of just the regular restaurant standards that we had before.
Okay, so what is your role currently as you sit here today? Are you still a waitress at 1145, or are you under some other role with this new establishment you just described?
I would say right now I'm helping Jabril with coming up with the concepts and expanding on what we're gonna do for Le Rev, and then we'll figure out, what's the best thing. What else?
And so, how long were you a waitress at 1145?
I would say probably about 5 years.
And so, so it's fair to say you worked at 1145 from 2019 to 2024?
Mm-hmm.
Okay, and in your time, can you describe your duties as a waitress at 1145?
As a waitress, my job was to create an experience for the consumers while they enjoy the different things that we have, from our great food options, great cocktails that we have, great lounge music that we have for the environment we created.
Okay, do you sell any bottles of alcohol?
I sold cocktail drinks. I would say mainly cocktail drinks, champagne. That would be the main thing of cocktails, champagnes, and soft drinks.
Okay, have you ever sold a bottle of alcohol in 1145?
Yes.
Okay, is that regular for your patrons to come in and order bottles of alcohol and you would bring them to the table?
Yes, because of the amount of people that we have sized per table, it would make more sense, it's more feasible for them to just buy a larger size, and then as a server, I will distribute it out to each guest.
Okay. And so you would ring that bottle up, one person would pay for that bottle, and then you would, as a waitress, you would distribute those drinks out?
One or more people would pay for that bottle, and then I would distribute drinks.
All right, fair enough. And then you said, what type of food do they sell at 1145?
We have lamb chops and pasta, we have wings, we have burgers, we have salads, we have a lot of appetizers, entrees for you to choose from. We have suya to give kind of an international flair to the menu as well.
Okay, and is there a menu?
Yes.
And do you have that menu with you today?
Do I have the menu physically on me?
Yeah.
No.
Okay. Is the menu, can the menu be found on 1145's website?
Yes.
What is 1145's website?
1145.com.
It's ELEVEN 45.
I would ELLEVEN.
45 Lounge.
45.com.
45.com. And what about, does 1145 have an Instagram page?
Yes.
Do you know what the Instagram handle is?
1145.
1145. And that's the Instagram handle that the business operates, correct?
That's one of the handles that they use, yes.
And so if on that website, on the Instagram page, if the Instagram page says that they're the #1 nightclub in Atlanta, that would be pretty accurate description of 1145, correct?
I would say they're the number one place giving a nightclub experience.
Okay, but I guess my question is, if they posted it on their Instagram page, would that be an accurate description of what 1145 is, if they put it up there?
Would it be an accurate description
Yes.
to consider 1145 a nightclub due to the fact that that's what they have on their page?
Yes.
I would just say that's one of the form of advertisement that they added to their page.
Fair enough. So a second ago, you testified that you have some prior restaurant experience. And so you've been employed with Local Luna? And what was your role at Local Luna?
In Local Luna, I was a hostess and then a server, and then I worked in to-go as well, the to-go station as well.
And you said you also worked at Buffalo Wild Wings. Which location?
The one in Buckhead.
The one in
It's
Buckhead?
closed at the moment.
Across from Phipps Plaza? Okay, and what did you do at Buffalo Wild Wings?
I was a hostess, I was a waitress, I was shift lead, I worked with the community on doing a lot of college outreaches with Clark Atlanta University, Morehouse, and Spelman.
And based on your experience at Local Luna and Buffalo Wild Wings, would you agree that they're a restaurant?
Correct.
And would you agree that their operation is totally opposite of the operation at 1145? Okay, let me ask you a question. What time does 1145 operate?
1145 operates from,
I'm sorry to interrupt, but was your answer to the totally opposite question no or yes? He said, would you agree it's totally opposite from those other restaurants?
I would say that is not totally operating.
Okay.
It's totally different.
Thank you.
Okay, so you're saying that 1145 is just like Buffalo Wild Wings and Local Luna?
I would say they do mirror some of the experiences that they have there.
Okay, and can you give me a description of how they mirror those, the same?
Well, I would say that they both run late hours, because Buffalo Wild Wings would run till 1 a.m. They would have bar kind of food, but 1145 expands on it with their dining experience, having lamb chops, while they primarily had wings and burgers. They also played loud music, had gatherings, had larger parties of 6-10 people. You're able to order pitchers where it has cocktail drinks that come in larger sizes that is able to be distributed between the waitresses. And They also have a bar. That would be very similar.
Okay, any DJ at Buffalo Wild Wings?
They have had one, but it's not on a regular basis.
You testified a moment ago about a new concept that you guys are going to be rolling out at 2110 Peachtree Street. And so 1145, for all intents and purposes, that's closed forever.
Well, it's not up to me. It's still in their decision on how they handle everything, but it will be LaRev when the door is open again.
Okay, and you're helping with the organization of this new concept. And so have you applied for any permits or anything to change the name to LaRev with the city of Atlanta?
That wouldn't be something I would know.
Okay. Do you know whether or not you've notified the landlord about this new restaurant concept?
That is something I wouldn't know.
Okay. And so, do you know has there been any work on the inside of 1145 to change it from 1145 to the Rev?
Well, I would say with the back stock of everything we've ordered for the restaurant, down from its plates and glasses and the new fabric and designs, and looking at all the different things online that we're ordering for the concept, just to bring it a new experience to Atlanta and then us.
Did you bring any of the plans for the Rev here with you today?
Well, the plans would be what I see in the security plan they have in here.
So the plans you're referring to is the menu and the operations, the new operation that you guys have put on paper. Those would be the plans.
That would be some, yes.
Okay. And so LaRev and this new plan and this new security company that you guys have put in place, that was in reaction to the shooting that occurred on Mother's Day, correct?
Yes.
Okay. And were you working that night?
Or was I working now?
Okay. In the past, since 2019, have you ever been to 1145 where shootings have occurred?
A shooting happening inside the club?
No, not inside. At 1145.
At 11:45 where a shooting has occurred? No.
What about outside in the parking lot? Have you ever been there, or while you were employed with 1145, has shootings occurred in the parking lot outside?
The honest answer would have to be the tabloid says such, but I'm not sure that I can actually say I remember the exact date or if I was actually there when that happened.
That's not my question, Ms. Benson. I'm not asking were you actually there. I'm asking, are you aware of any shootings that occurred at 1145 in the parking lot or inside since you've been employed since 2019?
Yes, I am aware of a shooting happening on Bennett Street and Peachtree since I've worked at 1145, correct.
Okay. Are you aware of fights that have occurred in 1145 since you've been employed since 2019?
Yes.
And how often, how frequent do those fights occur?
I wouldn't say the fights are often because a lot of the time the security guards that we have inside and outside, they're pretty good at de-escalating the situations as they're happening. There is enough of them positioned in different stations for them to kind of see any type of frustration happening before they expand. So,
are you aware of any stabbings that have occurred inside 1145 since you've been employed since 2019?
A stabbing?
Yes.
No.
You're not aware. All right. Going back to this new concept, this LaRev, how do I pronounce it? LaRev. Is that going to be under a new owner, or is that going to be under Mr. DeFay still?
That's something I would know.
Okay. So you're not aware whether Mr. DeFay has already sold 1145, or if there's a new owner, or whether it's gonna be Mr. DeFay running his new restaurant at the property.
Well, that would be above me, so I'm not sure.
Okay. All right. And you, do you have any experience running nightclubs?
Do I have experience running a nightclub?
Yes.
No, not running a nightclub.
Okay. And what about the security company that you met with?
Mhm.
You testified to that a moment ago, correct?
Mhm.
What was the name of that company?
Lion Gates.
Lion Gates. Okay. Do you know whether they're a licensed security firm
License as in,
to perform security services?
well, I would believe so with everything that they supplied over the documentation.
And what
I have not personally vetted to see if everything is correct.
So you've not personally vetted these folks?
No, I have not personally vetted their documentation. I've seen it, but I have not personally vetted it to ensure anything.
And what documentation did they provide to you?
Just their insurance and that's all. Basically, the interview with the insurance, and that was it.
But they didn't provide you with any licenses for the city of Atlanta?
I personally wasn't privy to that.
Are you aware that to perform security, you gotta have a license? You gotta be licensed with the city of Atlanta?
I would believe they would.
Okay. No, I'm asking, are you aware that you have, for a security company, you have to have a license to provide security?
No, I'm not aware.
Now, so going back to Lion Gate, you said they performed other security. What other clubs do they perform security very hard?
I'm not sure of all the clubs that they do security at, but I know them from Icebox. That is the place where I know them primarily from, and then I know of them letting me know about the different restaurants that they have worked with as well.
Okay, Icebox is a jewelry store?
Yes, it is.
Okay. And what about, you said the other restaurants, what other restaurants?
I don't remember at the moment the list of names that they gave me.
You don't recall not one?
No, I don't remember at the moment the list of names they gave me.
Okay. Now moving on, you said a moment ago that you all purchased metal detectors. Did you purchase the metal detectors?
Yes, I was the one that ordered them.
And did you get with the security firm, or you just ordered a metal detector?
I did some research online on what a lot of the airports and I would say other restaurants and other like event spaces use for metal detection. So I looked up stuff like that online and researched it that way.
And what restaurants did you look at for to kind of compare?
I looked at what's the name? It was they have them listed on their website for Garrett, the place that they're affiliated with. I can't recall off the top of my head.
Okay. I understand. All right, going back to your time as a waitress at 1145, part of your duties, do you sell hookah?
Do I sell hookah?
Yeah, does 1145 sell hookah?
Yes.
Okay, and as part of your duties as a waitress, do you bring the hookah to the table, or is something
I don't
else
do
about
that. No, I don't do that.
So your primary role is just to serve alcohol?
My primary role is to serve the customer with cocktails, drinks, and just their experience of everything.
Do you know whether serving hookah being consumed in the premises, do you know whether that's a violation of the lease?
No, I do not.
Okay, but there are folks consuming tobacco products inside 1145, true?
Yes.
What about marijuana? Is there frequent marijuana smoke in 1145?
I would say I can smell that on guests a lot of the time, but I cannot actually say that I'm watching them do it.
Ms. Pan, you're under oath.
I am
Is
under
this your testimony that you've never seen folks smoking marijuana in 1145?
I said that I can smell that on them. I'm not necessarily paying attention to every guest that's on the premises.
That's not my question, Ms. Pan. My question is, have you ever seen folks smoking marijuana in 1145?
I'm sure I've seen it before.
Okay, and are you aware that's against the lease?
No, I don't know what the lease contains.
Will the new restaurant, the Le Rev, will you guys be serving hookah?
Yes.
Okay. Will you guys be selling bottles of alcohol?
That hasn't been decided not.
Okay, will you guys be selling sections?
Tables, they will have table minimums where they might have to pre-book or something like that, but that would be just it.
In the past, explain to the court what a section is.
A section will be an assigned area that you will be seated that has a minimum that is required for you to dine in that specific area.
And in that minimum, does that come with food and liquors or just liquor?
Food and liquor.
Okay, and so if we had testimony that someone bought a section but only received liquor, what would be your response to that?
They have the option.
Okay. So some of the minimum, you can get all liquor.
If you choose.
What is the average cost of a section at 1145?
I would say about $750, $1,000.
And you guys charge a door charge at 1145, correct?
Sometimes they charge entry.
Okay, and how much is the entry?
I honestly do not know.
Are you guys gonna be charging to cover at Le Rev?
That's something that hasn't been decided yet.
When you worked at Local Luna and Buffalo Wild Wings, did you guys sell sections there?
Local Luna, yeah, they had assigned areas that you can pre-book for certain fees and costs. But mainly, it would be after the flow of, let's say, 5 to 10 experience.
Well, I guess my question is not places where you can book, because I'm sure all restaurants have private dining rooms. I'm talking about comparing it to 1145. Did Local Luna and Buffalo Wild Wings sell sections like you sell at 1145?
Buffalo Wild Wings, no. Local Luna, yes.
They sold sections?
Yes.
Okay. And did Buffalo Wild Wings and Local Luna, did they have a dance floor?
Local Luna, yes, has a dance floor.
And so, as you sit here today, all these plans for the Rev, they're not firm plans yet. Would you characterize that as true?
I would say with the spending that we've done so far, they are pretty firm.
Well, you just stated you didn't know whether 1145 was done, it was over.
I said it's firm plans. That is a firm plan. Now, what is done with 1145 and transitioning to the rec, I have no idea.
So the exhibits that you just went over with Mr. Bailey, those are just maybe prospective things that may occur in the property. There's nothing firm yet.
No, that is the full intent of going forward. When the doors open again for 2110 Peachtree, it will be Lorette.
Okay, and it won't be 1145.
No,
And it won't be a nightclub.
it will not be a nightclub. No.
And would you characterize, and so this is my last question, do you believe that 1145 had any characteristics of a nightclub?
I would say 1145 carried the experience of nightclubs as well.
Thank you. No further questions.
Any cross from you?
I represent Bennett Street Properties, who's the landlord. Have you ever been in contact with anybody from Bennett Street Properties?
No.
Okay, did you make Bennett Street Properties aware of this new development that you guys are working on?
Not me personally.
Thank you.
Can you redirect?
Yes, just real brief. You mentioned you'd seen the insurance policy of the security company Liongate, and you'd seen some documents. Did you see any documents that showed that their business was located in the city of Atlanta, therefore requiring a business license in the city of Atlanta? Did you see any documents from this? Did you see any documents showing that they were actually located in the city of Atlanta?
Yes.
What address did you see?
I don't remember the exact address.
The business address?
No, I don't remember.
No, do you remember a business address like being located in Atlanta, not them working in the city of Atlanta, the business address?
Okay, I'm kind of confused with the question.
I'm asking about the business address of Liongate. Opposing counsel asked about seeing business licenses from the city of Atlanta, which are required for business that are located in the city. I asked if you'd seen any documentation that showed that Liongate's actual corporate address is located in the city of Atlanta.
No, I didn't.
Okay, thank you. I just want to clarify that for the record. Also, regarding the security company, are you aware of any policies or plans are you aware of what the security plans are regarding female patrons moving forward?
Yes, we definitely made sure that in our conversation, there will be a female security guard there during operation at all times.
Were there female security guards working at 1145 prior to the May 12th incident at all times?
I can't attest to all times.
Okay, but going forward, your testimony is that there will be security guards at every time. Okay, that's all. Thank you.
Any recross based on that?
So all the plans that you're talking about, all this stuff is prospective, right? None of this stuff was instituted in the past, correct?
What do you mean?
Meaning the females being pat down. That was not a practice at 1145, correct?
A female being pat down, I can't attest to what security protocol was as far as that's concerned for 1145.
So you've been working there for 5 years and you don't know the security protocol?
I did not work outside, I worked indoors.
Okay, so when you came to work, you weren't subject to search?
Me personally, no.
So why was it important that you just stated that this new security plan will include pat down of females, correct?
Yes.
And so why was that important to put in now? Is that because that you guys did not have the security measure previously?
I would say that maybe that they didn't have it like all the time. Maybe it was something that they might have had somebody come, maybe when they have more holidays or something like that possibly, but now they're gonna make sure that it's something that is assigned there during all operation.
Okay. And when you come to work at 1145, you drive?
Yes.
And you pull into the parking lot?
Mm-hmm.
And before you get there, is it a lot of traffic getting into the parking lot?
No.
Have you ever seen it where traffic is down Peachtree Street?
Yes.
Okay. Have you ever heard of any complaints that because of 1145, it's a bunch of traffic down Peachtree?
Well, I actually lived right next door to 1145, and I've never heard of any complaints personally.
Okay, but you as a resident of nearby 1145, you witnessed how somehow the traffic can be snarled because of 1145.
I object to the extent it's exceeding the scope of redirect.
Oh, he's permitted to cross her about other matters. Go ahead.
You can answer.
Okay, ask the question again.
As a resident, you said you live or you lived by 1145?
I lived.
Okay, and so your experience living near 1145, did you ever experience traffic being backed up because of 1145's operation?
I can't say it's because of solely 1145, but I've experienced traffic backed up on Peachtree from the Bennett Street, from Houston's to Benihana's, being the main three places that would have traffic.
How close did you live from 1145?
500 feet, 600 feet,
And did you live in a house or an apartment?
an apartment building.
Has you ever, from your home 500 feet away, had you ever heard the music at 1145?
No,
Never.
no.
And so, even though you lived that close, you used to drive to 1145?
Mhm.
And when you drove there, did the valet park your car or you parked your car?
Sometime both. Sometimes, knowing the valet personally, I can get them to park my vehicle, or I can but it's primarily a self-parking parking lot.
And so you knew the valet personally?
Some of them, I mean, if you're there every day, then eventually you'll just say hi more than once.
And so the valet company is not a part of 1145 staff?
No, they're a third party.
Okay. And have you ever seen security guards in the parking lot with the valet company?
Have I seen security guards
Yeah.
in the parking lot with valet? I've
Yeah.
seen APD.
Not APD, I'm referring to security. Have you ever seen any security in the parking lot with the valet?
I see, the only time I really see security in the parking lot is when they're doing their rounds, walking around the premises.
Okay, but you've never seen security with the valet company?
No.
Nothing further?
Anything further?
I do.
Oh, okay.
Okay, the security that is in the parking lot, do you know them?
Some.
Okay, are they off-duty police officers?
Yes.
Okay, do they wear any type of uniform?
Yes, sometimes. Oh, I would actually say yeah, I do.
Okay, what uniform do they wear?
That would be a question, yeah. I would say a police uniform, or.
But aren't they off-duty police officers?
Yes.
So, you're telling me off-duty police officers are wearing police officer uniforms?
Yes.
Okay, but do you know who employed them?
No.
Oh, thank you.
Just got one question, Judge. Ms. Patton, the AP officers that you just referred to, are those the same officers that would be there for 1145 that 1145 will hire, or they be separate officers employed by the valet company?
Well, I know 1145 has secured, I guess APD or whichever with them as well, but the ones that I'm referring to are additional ones that are in the parking lot.
Fair enough, thank you.
Any redirect? Okay, you can be excused, thanks. Any other witnesses for? Okay. And you have for Bennett Street, you're gonna call one witness?
Yes.
Okay, we need to take a 5-minute break.
No, go ahead. Yeah. Just to say that all duty officers are outside the club, they're not inside the club. Policing inside the club or enforcing anything within it. Yeah, and I did the outside, the actual officer is the one who called it in, that the shots fired and officer.
Court can order remain seated.
Okay, ready with your witness?
Yes, you are. Venice Street property is called Frank Brown, Jack Brown, I'm sorry, I don't know why.
Oh, you know what? We're missing a lawyer. Sorry.
He's gonna get.
He'll be back in a second.
I can.
You can go ahead and be seated or get sworn and be seated.
Raise your hand. Do you swear affirm the testimony you give to the court is the truth, the whole truth, so help you?
I do.
Go ahead and have a seat and answer the mic, state and spell your name for the court.
Mr. Brown, I'm sorry.
Jack Brown, JACKBROWN.
Mr. Brown, would you prefer to be called Mr. Brown or Jack?
Jack's fine.
Thank you. So, Jack, tell us, what do you do?
I am the, one of the owners of Bennett Street Properties, and I'm the managing partner for that partnership.
Okay, so, let's talk about Venice Street. You say you're on, one of the owners, how many partners are,
4 total.
okay, and do you have any employees?
No.
Okay, do you have any contractors?
Yes.
Who are your contractors?
We use various contractors from time to time, depending on what we need to have done.
Okay, do you have a contractor for cleaning, for instance?
Occasionally, yes.
Okay, do you have somebody that comes to clean the common areas?
Yes.
Okay, do they, how often?
7 days a week.
Okay, and, are they employees or contractors?
They are contractors.
Okay, do you have an office?
Yes.
Where is the office located?
At Bennett Street, at 55 Bennett Street.
Okay, so I'm gonna bring it out, again, this is being accepted as the demonstrative, and it's just basically the Google view of the property.
This is Zoom on there?
Yes.
Are you on the
Is it
Zoom?
working?
Yes, it should be. There's a different one for today from yesterday.
Okay.
Do you have anything on your screen?
No.
Just that Zoom workplace?
Well, I have everybody, but
Oh, you do have pictures of everybody?
I have pictures, yeah.
Laura Schuster. It's in the same email, it's just.
Okay, the witness does have it on his screen though.
He does the map,
No, he just
No.
has, he has the Zoom on the screen.
the Zoom on screen.
So he'll have to share. Screen again like yesterday. And I'm into the Zoom now too.
Fine, okay, I found it, the second link. Okay, nice. I just need to do that in.
Yeah.
But, sorry.
I printed, there's just dots. There you go.
Okay, now we're.
Okay.
So I showed that before in court, and can you show to me behind you, if you look behind you, there is a bigger picture of it. Can you just please show it with your finger, the part that belongs to Venice Street Properties?
Sure.
That screen makes marks, so if he touches his screen, he can circle it for you if you want.
You can
Not
touch your
that
own
screen, the one in front of you. Sorry.
Oh, I can do it
That one
here.
doesn't look like
That's
that.
Okay,
even better.
let's see if I can do this.
You might have to tap once to get a counter.
Okay.
Oh, is he supposed to use the clicker or his finger? It's just a touch screen, right?
There, yeah, there should be like a.
Did that do
pen
anything?
icon. Is there a,
Where is that? Down on the bottom right-hand side?
Yeah, share content, yeah.
So,
Thank you.
about 1 out of 10 witnesses knows how to use this, so we help always.
And
I didn't know that was the-
I always forget because nobody ever does it. Yeah.
it's like an annotation.
So like,
Okay, that cannot be it.
now we know it works.
Okay. So much.
okay. Now let's see if I can get this correct.
If it doesn't work for you, oh, you got it.
There you go. Okay. So, so that part of Bennett Street Northwest, does that belong to Bennett Street Properties or it belongs to the city?
Well, actually, Bennett Street runs, that's Bennett Street. And this is Tula Street. And everything, even though it says Bennett Street Northwest here, that is not a street. That's a common way.
so it
belongs
belongs,
to us.
it belongs to Bennett Street Properties? Okay. And Bennett Street Properties let the public use as a public passage,
Yes.
but,
Correct.
okay. And, so on that property, this whole property, how many tenants, does Bennett Street Properties have?
We've had as many as 23 and as few as 16, and we probably have about 18 right now.
And I forgot to ask you that, so how long has Bennett Street Properties owned that piece of property?
Most of the property we've owned for close to 50 years.
Okay, and then when you say most of the property, did you add property?
Yes, we bought the back two buildings 35 years ago, 40 years ago. So we've owned it for a long time.
Okay, and so, let's talk about 1145. In that building, how many tenants you have in that building?
2.
Okay, one is 1145, who is the other tenant?
There's a tailor who does this thing in the basement of 1145.
Okay, and how long has he been a tenant there?
Over 20 years.
And all the tenants that you have, so you have the tailor, and tell me other examples of other businesses there are within the Bennett Street Properties there.
Currently, we have a number of hair salons. We have Zari Cafe, Taranga, which is a food and drink establishment. We have a rug dealer who's been there for over 20 years. A sound studio. I think we have 2 sound studios that do recordings. Let's see, who else? We have a clock dealer, antique shop.
Okay, and, well, it's all commercial then?
Yes, all commercial.
Okay, and when you lease property within that, I'm gonna call it a mall for lack of a better word, but just not to say property within the property. So when you lease property within that mall for commercial, for a business, do you, when it comes time to licenses and other, licensing and permits to run each specific business, do you have any involvement in that?
No.
Okay. And, so as a, landlord, having all those business there, all of this, let me go back a little bit. So 1145, let's talk about 1145, that building. Since when it has been leased to Jijibru, Duffy, and 1145?
Well, it's been a while. I think maybe 2015, 2016. So.
Okay, and what was it before that? Do you remember?
Frank Ski's restaurant was there. It's been a restaurant pretty much since we've owned it.
Okay, and when you say restaurant, during the course of this hearing, we were able to learn a little bit about the different qualifications differences between a restaurant, a lounge, which apparently it's not really qualified, but a nightclub. Are you aware of all those differences?
I'm not aware of the differences that the city or state may require.
Under the law, I mean, are you aware of the differences?
That building is always had a tenant that had a liquor license.
Okay, but if I ask you, under the law of, and the ordinances of the city, before this hearing today, would you know the difference of between a nightclub and a restaurant and a lounge?
No,
Okay. Again, when you lease those properties, all compliance with city ordinances and licenses and state law require from a business, that's not a duty of Bennett Street, correct?
no, not at all.
Okay. Now, have you ever had the city of Atlanta filing suit against Bennett Street properties on a declaratory nuisance case?
No,
Okay, so this is the first time you've been going through it in 40 years.
yes,
And your other businesses in the area, have you ever had any citations coming from the city?
not to my knowledge, no.
Okay. So let's talk about the contract between Bennett Street Properties and 1145. Again, I'm gonna go back. So it is fair to say you were in the business of real estate.
Yes, we're
Okay.
landlords.
To somebody's business. And so does that property has a mortgage with the bank?
Yes,
Okay. And Bennett Street Properties is the holder of that mortgage, is the one that it has obligations to pay on that mortgage, correct?
yes, we are.
And your tenants have the obligation to pay you,
Yes.
correct?
Correct.
Okay, has 1145 ever missed a payment?
Well, yes, from time to time, but yes,
Have they corrected and brought themselves up to date on their payments?
except for currently, yes, they always have.
Okay, when you say except for currently, do you know when did they stop paying?
To my knowledge, it was after the shooting.
And when you say after the shooting, are you talking about the incident of May 12,
Yes.
24? Okay, I'm gonna get there. But before I get there, under the contract, well, actually, may I approach the witness now?
Yes.
This is the copy of the lease. Okay. So, Your Honor, this has been submitted on the Bennett Street Properties list.
Any objection?
Exhibits.
No, Your Honor.
Any objection? It's admitted.
Thank you.
They made it easy for you.
So it's being admitted into evidence, and go ahead and represent to you, this is the contract, the lease contract between Bennett Street Properties and 1145 Lounge, under their business name, which I believe is Sovereign Entertainment LLC, and Jijibru Daffy, is that correct?
Yes,
Are you familiar with this document?
yes.
Okay, so under this contract, what was the purpose for which 1145 leased the property?
Well, it's in here, I think it's a
Yeah, and I.
restaurant lounge,
Direct.
restaurant.
That's.
We spell it out.
Mhm.
Yeah,
it's-
restaurant and lounge.
Okay, restaurant and lounge. And so, for all that been happened, did you believe that 1145 held the licenses necessary and permits necessary to operate as a restaurant lounge?
Yeah, they would be required to.
Okay. Now, Street Properties ever made any representations to 1145 that the property was fit to run a nightclub?
Did the say that again?
Has Bennett Street Property ever made representations to 1145 that the property was a nightclub?
Has Bennett Street ever made representations?
Yes, has Bennett Street informed, when you were contracting with 1145, did you contract personally with 1145?
No, our property manager did.
Okay, who is your property manager?
Lee Nicholson.
Okay, is he an employee or a contractor or?
He has a contract through his realty company to manage the property.
Okay, and, by the way, is he related to you?
Yes,
How?
he's my son-in-law.
Is this a family business?
Yes.
So.
It's his business now, not mine.
Okay, so, what I'm saying is when Bennett Street Properties put the building out for lease,
Mhm.
did it mark it as a nightclub?
No, not as a nightclub,
Okay,
but as a restaurant and lounge.
okay. So, and when, under the contract, what were the landlord obligations which, in reference to cleaning inside, for instance? Are you
No.
obligated to clean inside?
No,
Okay, what about furniture? Did Bennett Street Properties furnish the
no,
building? What about determined equipment, like sound equipment, light equipment, any equipment inside? Does that belong to Bennett Street Properties?
no,
Okay. When it comes to providing employment or the employees of 1145, does Bennett Street Properties have any employee or any representatives inside the club working in the club?
no,
Okay, and security, when it comes to security, let's say from the door of the club to inside the building, does Bennett Street Property, under the contract, provides any security from the door of the building to inside?
no,
Okay, so when the club is admitting patrons or even excluding patrons and taking them from the inside, does Bennett Street Property has any saying on that?
no,
Do you operate, manage, or have any control how the business is, operated?
none at all, no.
Okay. Now, and when it comes to payments, there are made from 1145 to Bennett Street Properties. Is there a monthly rent?
Correct, yes.
Is there a established value? Or it goes, or it like, does Bennett Street Property rent increases based on the profit from month to month, for instance?
No,
Okay, does Bennett Street Property has any participation on the sales of alcohol?
no,
Any participation on the entrance fees?
no,
Okay, can you, as a landlord, enter the property at any time you want?
no, no.
Okay, so if you need to enter the property, what do you need to do?
I believe we're required to give them 24 hours notice.
Okay. And when they were deciding that this was going to be in this contract, a restaurant and lounge, is that something, did you have any saying in how the business was going to be developed? What was going to be the type of restaurant that they would operate?
No,
Okay, do you decide which music they're gonna play?
no.
Now, under the lease, what are your obligations? What do you do, concerning, the building, the 1145 building?
Well, he's responsible for the roof and the interior and continued maintenance of the building. We don't do anything.
Okay, is he responsible for the plumbing?
Yes,
Okay, lighting, electrical? Okay, what about, so we see the property is big and it, like you say, it has 18 tenants. I see a parking lot there. Do all the tenants of that property share the parking lot?
they can,
Okay,
yeah.
so who manages the parking lot?
Our valet service, there's a valet service that controls the parking lot.
Okay, but under the contract with 1145, they do not have anything to do with the parking lot, correct?
No,
Okay, who hires the valet?
we do, Street does,
Okay, is this, under a contract?
yes.
Okay, do you know if, once you, so do they pay Bennett Street in order to be a valet
Yes,
in that parking lot?
yes.
Okay, so is it right to say, do you control how the valet operates?
I suppose there's some standard we would hold them to, but no, not really.
Okay, do you
Yeah.
hire the people that work for the valet company?
No,
Okay, and when you say standards, is that under the contract?
I would have to look at the contract again, but yeah, they're independent. We hire them because of their reputation.
Okay, you say you hire them, do you pay them?
They pay us.
Okay, so normally when we hire somebody, we are paying them to do something for us.
Well, perhaps I misspoke. We contract, we put it out to bid, and they won the contract.
Okay, and under that contract, is the valet obligated to provide security to the parking lot?
Yes,
Do you know which type of security they are obligated to provide?
I believe that they're required to have uniformed police officers.
Okay, you mean off-duty police officers?
Off-duty, yes.
Okay, do you know how many?
I want to say 6, but I'm not,
That would be a minimum?
yes.
Okay. And to your knowledge, do they hire off-duty police officers?
Yes,
And you said you have an office, Bennett Street Properties has an office within that mall area, right?
that's correct.
Do you have somebody in the office every day?
Not every day, no.
Okay. Do you go to the office?
Sometimes,
How many times in a week would you go there?
maybe 3.
So during this whole hearing that we've been here for 2 days, we heard from many people, police officers, patrons to 1145. Have you or Bennett Street ever been contacted by law enforcement? Or is Bennett Street contacted by law enforcement every time that law enforcement needs to be on the property?
No,
Okay. And, but are you aware of some of the violent incidents that have been spoken of during this hearing?
Some, yes.
Okay, so I'm gonna mostly ask you about the ones that we heard testimony about. Officer Shingles, for instance, testified that there was a stabbing inside the 1145. Apparently some ladies were in the bathroom and there was a stabbing. Were you aware of that?
No.
Okay. When Officer Walker, for instance, testified that gunshots were fired from the parking lot of Fresh Foods into the street and, of course, across Fresh Market. Sorry, Fresh Market is 1145. Were you aware of that shooting?
You're talking about shootings from across Peachtree at Fresh Market.
Yeah. They were shooting from Peachtree towards 1145. Were you aware of that?
I heard about it.
Okay. Who'd you heard it from?
I'm not sure.
Was it a police officer that contacted you?
Not a
Atlanta
police officer, no.
Okay. Was a complaint from any neighbor?
No,
Okay. Was anything in writing that you received?
no.
Okay. So it was just passing by, you heard about it?
Yes, correct.
And we also talked about, we had some witnesses of the May 12, 2024 incident. And that was the one that unfortunately ended up the life of 2 young people. When were you made aware of that incident?
As best I can recall, within 1 or 2 days.
Okay. Was that because the city of Atlanta police or the Atlanta police contacted you?
No.
Okay. Do you remember how you heard about it?
We have a part-time person that works with us, kind of a liaison that from time to time he just checks on things. He told us. He lives nearby.
Okay. And by the time you knew, was 1145 already no longer operating?
I think that's correct. I think that the mayor acted pretty quickly.
Okay. And we also talk about other incidents. We'll talk about an incident, and I think that was Lieutenant Cotter or Cotter, I don't know how to say his last name, but it's C-O-T-T-E-R. He was actually talking about how he had to go to 1145 and do alcohol and, you know, and it had something to do related with their alcohol license. But he said that he heard that there was an incident with a firearm inside of Zari. Are you familiar with Zari?
Yes.
Okay, is Zari one of your tenants?
Yes.
Are you familiar with that incident?
I am familiar with an incident
Oh, okay.
in which a patron came out of the restroom, had a small caliber pistol in his pocket, and while he had his hand in his pocket, it went off and shot himself in the leg.
Okay. Were you aware of any other shooting instances at Zari?
No.
Okay. Did you receive, did the police contact you regarding that?
No.
Now, there was another incident that he talked about where there was actually somebody that also died due to a shooting
Yes.
in the property. And that incident, I believe he said, was at Level 5 Lounge. Do you know what the incident I'm talking about?
Yes. There were some men on Bennett Street that randomly fired into the upstairs of our building at 2101 Tula Street, just randomly fired, and it went through the window and hit a patron.
So he hit somebody that had nothing to do with that?
Had nothing to do with it.
Okay, so once Bennett Street Properties became aware of that, and that involved people that were attending the Level 5 lounge, what did Bennett Street Properties do?
Say that again?
So once Bennett Street Properties became aware of this previous incident with Level 5 lounge, what was the next step that Bennett Street Property took concerning that tenant?
I'm not sure whether we evicted them or, anyway, they moved.
Okay.
They vacated the property.
Okay. Did Bennett Street Properties take any other security measures, of course, in the common areas?
No.
Did you install cameras?
Oh, yeah, I should remember that. We have we installed 27 high definition cameras on all the buildings that I can actually see on my phone.
Anything else?
We have one camera that's a license tag reader. And one of the unique things about Bennett Street is it's one way in, one way out. So everyone that leaves is photographed. Every car tag can be read.
Okay. Has Atlanta PD or any other authority ever requested footage or
Yes.
from that? And
Yes.
did Bennett Street Properties collaborate?
Yeah, we download it and give it to them.
Now, and again, when it comes to alcohol licensing in the property, have you ever applied for an alcohol license for
No.
that property? Okay. Now, let's talk a little bit about the patio that we talk here on this hearing that, it's according to the city of Atlanta, it does not have a permit for it and is illegal and, is being considered to be, I don't know if dangerous was the word that they used, but, Bennett Street Properties built that patio?
No,
Did contract with anybody to build that patio?
no.
Okay. Under the contract with 1145, could 1145 make modifications like build a patio, for instance?
Well, they're supposed to let us know.
Okay, did they let you know?
They showed us plans they showed us a rendering for an awning or umbrellas on the patio, but that was all.
Okay, and the final product, was it close to what you or Bennett Street Property has permitted them to do?
No,
Okay. Have you ever received any notification from the city, either from the building department or for the zone enforcement, that that patio was not according
no.
to ordinance? When it comes to noise in the property, can Bennett Street Properties under the contract issue citations against 1145?
Not citations, no.
Okay. And what can you do if for instance, they are cited for a noise violation?
The only thing we can do would be move to evict them.
Okay. And what can you do when, well, let me go back. Under the contract, can patrons of 1145 smoke inside the building?
They're not supposed to, no.
Okay.
It's a violation of the lease.
Okay, now, let's say it's another violation of the lease. What is your remedy, to fix that?
Eviction.
Okay. And you would have to get an attorney, file suit, prove that they breached the contract, and then evict them, correct?
Correct.
But you don't have any power as the landlord to actually enforce them to stop?
No.
Okay. Do you check with every single one of your 18 businesses that are on that property to see every single license and permit that they are needed for their specific businesses?
No.
Okay. So you just, if they are working and if the city doesn't come, or if you don't receive anything in writing, do you assume they are, they have all their permits and
Yeah, we
licenses?
assume they're in compliance.
Let's talk about the water. Who is responsible to pay the water at the 1145 building?
Mr. Jabril.
Okay. And did you ever receive copies of his water bill?
Not until recently.
Okay, why not until recently?
Well, my administrator sent me a copy of what was owed when we attempted to have the water turned back on for the tenant, for the tailor that's downstairs. The water was turned off after the city closed the club.
Okay. So was that the first time, after the water turned off, that was the first time Bennett Street Properties were made aware that there was such a large billing out there that was pending?
Yes.
Okay, and right now, who is paying for the water bill on that building?
Well, going forward, it's in the name of Bennett Street Properties.
Okay, so,
Turn the water back on for the tenant and so we could flush toilets.
okay, but now Bennett Street Properties is responsible for
Yes.
the water bill. And if Mr. Duffy or 1145 does not pay the bill to the city, who is gonna end up paying the $78,000 bill?
Bennett Street Properties, city will hold us responsible.
Okay, and then what would be your remedy? You would have to again file suit?
File suit, right.
That's all I have, thank you.
Okay, cross-examination.
Good afternoon, Mr. Brown. My name is Erica D. Smith, and I represent the city. You said your office is at 55 Bennett Street, is that correct?
Yes.
So looking at the map, you would have to pass 1145 in order to get to your office, isn't that correct?
Yes, it is.
Okay. I just want to go through your lease page by page, or well, some pages by page. It has already been entered into evidence. So what is the permitted use for 2110 per your lease?
Restaurant and lounge.
Okay? The lease specifically says that the premise shall be used for the following purpose and no other purpose whatsoever. You have sat through this whole entire trial. Hasn't it been brought to your attention that it's been used as a club?
Yes,
Okay. You said that the property is managed by your son-in-law, is that correct?
yes,
Okay. Has he ever visited the property of 2110 Peachtree, 1145 Lounge?
you mean to go inside it when it's open?
Yes.
Not to my knowledge, but I don't know.
Okay. Do you ever from time to time, or does your son-in-law, your property manager, inspect your properties?
Yes, we both do.
Okay. So upon inspection, the way that the seating arrangement is arranged, it never occurred to you that it was not a restaurant, but it was a club?
I've never made the distinction between what a lounge and a club is.
Okay. Also, you say that you go to your office anywhere from 2 to 3 times a week, is that correct?
Yes,
Okay, so you have to pass the deck at 1145, right? You pass right by it every time you go to your office.
correct.
Okay, so isn't it true that you observed that it was an enclosed structure? Isn't that correct?
That what is an enclosed structure?
The deck is now, in the patio, I'm sorry, is
Oh,
enclosed.
the patio,
Okay.
yes.
Okay, but your testimony was that they said that they showed you plans that they were gonna have umbrellas and that kind of thing. The plans did not include that it be enclosed, isn't that correct?
That is correct.
Okay, but your lease agreement provides that, and I'm reading from 2.2 in your lease agreement, is that the tenant must provide, must be in compliance with applicable zoning ordinance, and they shall obtain all permits and licensing required for business. Did you ever ask for those permits, seeing that it was not what they purported it to be to you in the plans?
No, I never did. And it's a surprise to me that he's not in compliance.
Okay. Also, your lease agreement requires annual reporting. Has Mr. Doffey given you those annual reports in a timely basis?
No,
When is the last time he provided an annual report?
I don't know.
Has he ever provided an annual report?
I can speculate, but I don't know.
Okay, let's go into section 6. Section 6 provides that the business must be open continuously. Isn't it true that this business, since May 12th, the business has been closed?
Correct.
So the business has not been open continuously. That's a breach of your lease, correct?
Yes, it is. A greater breach is that he hasn't paid his rent.
Also, you said your office is there. What time of day do you work? What are your normal working hours?
I usually arrive around 10:30 or 11.
But you're in business for yourself, so you can come and go as you please, correct?
Yes, I can.
But have you ever experienced problems with traffic along Bennett Street in the parking area?
Personally,
Personally,
no.
has anybody ever complained to you about traffic congestion?
Yes, they have.
Okay. And did you have a conversation with your tenants about the traffic?
Yes.
Okay. Do your lease agreement has a do not disturb section, is that correct?
Yes.
Okay. And can you tell the court what that do not disturb section says.
Can you tell me what the section is in the lease?
7.3. Mr. Brown, I'll help you out. It says the tenant shall conduct its business in a manner that does not reasonably disturb or become a nuisance to landlord or to other tenants or occupants of the shopping center, including without limitation unreasonable disruption or interference with any other tenants or occupants' right to peacefully and quietly enjoy their premises free of noise and vibration from the music played from the premises. Is that what the lease agreement says?
Yes, it is.
And sitting through this whole entire hearing, you have heard other business owners say that the noise and the traffic have precluded them and interrupted their business, that they had to conduct their fundraisers and other events off campus somewhere else. Isn't that correct?
The easy answer to that is yes.
Okay. So that is a violation of the lease, correct?
Well, actually, the complaints were not my tenants.
1145 is your tenant, correct?
Yes.
And you have heard testimony that the 1145, the noise, the vibration, the traffic emanating from 1145 has interfered with the quiet enjoyment and peace of other occupants, not tenants, but occupants of the shopping center.
They're not part of my shopping center.
Okay.
However, I agree with you.
Isn't it true that you derive revenue from 1145?
Yes.
Okay. So you want them to stay in business because you profit from them being in business. Isn't that correct?
This is a close call, but I'll be candid. We have been in this neighborhood for 44 years. We've been good neighbors. We expect our tenants to be good neighbors. We expect our tenants to comply with all their ordinances. We expect them to conduct themselves in a way that they fit within our neighborhood, just like any other establishment, just like we would want the shopping center next door to us to be. It's disturbing to me that they have not been in compliance.
But my question is, because you profit from them, you would like for them to stay in business. Isn't that correct, Mr. Brown?
I would like someone to be there that pays us rent.
Okay. And for right now, under this lease agreement, it's Sovereign Entertainment, AKA 1145 Lounge. Is that correct?
Correct.
Okay. Is there anything in this lease agreement, you've heard testimony from Ms. Panton that they're going to change the name and transition into this new restaurant. Under the lease agreement, is that prohibited?
I believe under the lease agreement, they would have to give us notice of that, and they would have to secure our, we would have to agree to whatever their changes are. But we haven't been notified of that.
Okay, but as long as they pay their rent, you're good, right?
Not necessarily, but
Okay.
yeah.
Under your lease agreement, it also provides that their tenant is supposed to be in compliance with all state and local laws. Is that
Yes.
correct?
Correct.
And you've heard testimony that they're not, in fact, in compliance with local laws, especially when it comes to their patio, as well as when it comes to the patio. Is that correct?
Yes.
Again, Mr. Brown, in order to get to your office at 55 Bennett, you have to pass 1145. And to get to your office, on your right-hand side is the patio, correct?
No,
Which side is the patio on?
patio's on Peachtree.
Okay, but you have to pass it, right? In order to get to 55 Bennett,
No,
okay?
not from where I come from, but
Okay, but you have passed the patio, correct?
yes, I know where the patio
Since
is.
November, since August of last year.
Yes, correct.
Okay, and did you ever see that, big sign on it that it was a unsafe building? The
No.
placard that was on it that's an unsafe building,
No, I never noticed that.
okay? Did your property manager, your son-in-law, ever tell you, hey, Dad-in-law, there's a placard on that building?
He doesn't call me Dad-in-law.
Okay,
Anyway,
Mr. Brown, whatever
he
he
calls
calls
me
you.
Jack.
Jack.
Kenzie.
There's a placard on the building. It's unsafe. We might need to talk to Sovereign Entertainment.
I don't know about that. And if I did, I would want to talk to him about that.
Okay. Under section 14, utilities,
Okay?
the tenant is responsible for the utilities, is that correct?
Yes,
But you have heard that they are over $78,000 in arrearages with the city of Atlanta, is that correct?
yes,
But being an arrearages, for any utility is a breach of the lease agreement, is that correct?
yes.
Objection to the relevancy of any information that he was not aware of prior to this hearing, that he just heard in testimony, to the extent that.
I don't think you have standing to object. Do you have an objection?
I do.
Okay, go ahead.
Mr. Brown, you gave testimony that you actually had the water turned back on, is that correct?
Correct.
So you knew or had reason to know that the water was turned off, correct?
Yes,
Okay. And, the water now is in the name of Bennett Street Properties?
correct, yes.
But is there running water as we sit here today at 1145 Lounge?
Yes.
So you paid the city $78,000?
No, we just had the water turned back on. We still owe the city $78,000.
Have you ever seen any advertisement from 1145? Any advertisement?
No,
Okay, but doesn't your lease provide that any advertisement cannot be sully the name of the shopping center, correct?
yes, correct.
Also, there's a provision of the lease that there's no smoking, correct?
Yes,
Okay, so, but you've heard testimony as that there is hookah as well as marijuana smoked on the premises, is that correct?
yes, I've heard that.
And that is a condition for a breach of the lease, is that correct?
Yes,
You've heard the testimony of Officer Walker that the shooting was from Fresh Market and aimed towards 1145, is that correct?
yes,
Okay, and the fence was also damaged, so you knew or had reason to know that there was a shootout, correct? Because your property was damaged, isn't that correct?
I'm not sure that that's how I heard about that or knew about it.
Okay, so, let me get this straight. They have not been open continuously, correct?
That's correct.
They haven't paid, rent in a timely manner, correct?
Correct.
Is smoking on the premises, correct?
Correct.
You haven't got any annual statements, any income, have they ever provided any licensure to you?
No.
When your attorney asked you that you don't have grounds to issue citations, but you have grounds to evict,
Yes, I do.
in all the enumerations that they are in breach of contract, have you initiated dispossessory?
I believe we have.
I don't think you have. Thank you, nothing further.
Good afternoon. Earlier you mentioned that Ministry hires valet, correct, for the parking lot
Yes.
across the street from 1145? Does 1145 receive any money from the valet operations?
No.
Do they have any say in the valet or any control over the valet?
No.
You mentioned how the valet is required to hire off-duty officers. To your knowledge, does 1145 hire off-duty officers as well?
Say that again, please.
To your knowledge, does 1145 also hire off-duty officers outside his premises?
I don't know.
The city mentions the water bill. Do you have any personal knowledge of 1145 actually operating its business without water?
No.
When you testified earlier, that it was brought to your attention that 1145 is being used by a club. Are you referring to brought by your attention by the testimony of the witnesses today? Is that what you're referring to?
Yes.
Wait, would you ask that one more time?
When you mentioned that it was brought to your attention that the premises have been used that the premises have been used at a club, what you're referring to is the opinion of the witnesses that you heard on the stand from the city today.
Correct.
Thank you.
How many tenants do you have again? Did you say it was 22?
Somewhere between 18 and 20 or 21.
And approximately how long are the majority of the leases? Approximately how long are most leases with the tenants?
Currently, what is the length of lease?
Correct. The number of pages. Sorry.
Oh, 70 something,
70 something. So,
maybe.
as a property owner, how routinely do you go through each tenant's lease section by section to review their compliance?
Rarely.
Rarely. The city went through a list of code sections of your lease, and you tested and they asked you questions about the compliance of 1145. Did you have personal knowledge of breaches of the lease prior to the day hearing testimony, or did you learn about potential breaches during the testimony today?
What would be an example of that?
The city brought up about the utilities. They brought up about smoking inside, for instance.
Well, I was aware of the utilities because they've gone through my administrator now.
When did you become aware of the utilities? Was that in May of this year you're referring to?
It was May or June.
Okay, so that was very recently. And to your knowledge, you didn't have knowledge about any illegal use or any unpermitted patio prior to today for 1145, is that correct?
Correct.
Regarding the trade name, has 1145 operated under the new trade name that was mentioned today? Have they operated under that trade name in violation of the lease yet?
Not to my knowledge.
That's all.
Any redirect?
Jack, you just testified that you became aware of the water in May and June when they cut the water, correct?
Correct.
And then that they are not open, also that happened around May and June.
Correct.
Regarding not paying rent, before the event in May, was 1145, had any outstanding amounts of rent owed? Let me rephrase, before they were closed, did they have a balance owed?
Not to my knowledge.
So, let me see if I understood your testimony is that they might not have paid the rent always in time, but did they pay the rent?
Correct, yes.
In regarding to smoke inside the property, well, have you ever been inside 1145 when they were having an event?
No.
Okay, have you ever attended any, ate there, had a drink inside
No.
when this? And so you didn't have any personal life that there was a smoking
No.
inside? So is it correct to say that the first time you hear about it, it was during those hearings? During
Yes.
this hearing? Annual statements, what would that annual statements that they have to, your tenants have to give to Bennett Street, what do they encompass? What exactly is Bennett Street looking?
Well, the way we've operated is that from time to time, we've asked tenants, primarily for insurance purposes, to give us an annual P&L.
Okay, did any insurance company has requested that from Bennett?
Not in some time, no.
Okay. When it comes to the patio, so clearly the plan that they submitted to Bennett Street Properties and the final product were different.
Correct.
When you
yes.
saw the final product was different, why you didn't, did you approach your tenant at the Jabril to talk about it? Or, sorry, you or Lee Nicholson, who is your son-in-law, who is the manager?
He and I discussed it. I believe he was to have a conversation with Jabril. I don't know that we took any action around it. We did note that it seemed to, it might interfere with anyone on the sidewalk.
Okay.
That's all.
So, let's say in May and June, when you became aware that at least that the water was not running anymore, that they were in arrears for almost $80,000, and that they were not open anymore. So when you became aware that they were in breach of the contract, let's say you decided that you were going to evict them. Have you ever been through the process of eviction of a tenant?
Many times.
Okay, is that an easy process?
No, but we do it.
Okay, and do you evict tenants only because they are not paying the rent, or are there any other reasons?
There are plenty of reasons to evict a tenant.
Have you ever evicted a tenant before for other reasons other than not paying the rent?
At Bennett Street.
Yes.
I don't recall that we have. We may have filed. Sometimes the act of filing leads to negotiating with the tenant to leave, so we don't actually have to evict them. We did do an eviction earlier this year, and we had to go right down to setting everything out on the city street.
Okay.
So we've been through the process.
Okay, so let's say if you file an eviction as soon as after, right at end of May, beginning of June, how long would that process take?
60 to 90 days.
So you might, if you had filed, it might, and we are now on August 2nd, it might still not.
Well, unfortunately, the Fulton County Marshal Service for many years has remained short-staffed and they do the best they can, I think, but often we've had to go to a private service for the eviction itself, and we've had to wait quite a while to actually have the service take place. I don't blame them, I just notice it's part of the fabric of being in this business.
And do you consider yourself a generous landlord in the sense that do you give chances to your tenants to fix any errors?
Yes, we do, yeah. It's better to try to work it out than it is to, I don't like to be the hammer, unless I have to.
And has the city ever approached you, either the buildings department or the police or the zoning? Did they ever approach you or send you anything in writing regarding any of those issues we have been hearing here?
No, none.
Thank you.
Hello again, Mr. Brown. When counsel, Mr. Bailey, asked you if 1145 has off-duty security, isn't it a condition of your lease that they must have off-duty police officers when they're open?
I believe that's correct, yes.
Okay. Well, it is correct. It's in section, it's under Exhibit 8,
Yep.
under 6.
Yep.
And it reads in pertinent part, tenants must employ qualified security in the form of off-duty police officers on the premises when open. So they're not doing this to protect their patrons, they're doing it as a condition of their lease. Isn't that correct?
Well, I can't speak to that, why they do it, but it is a part of the lease that they're supposed to.
Okay. And earlier, when I asked you questions about dispossessory, and your response was that you're in the process of dispossessing 1145, is that correct?
Well, I'm not positive about that, but typically if a tenant doesn't pay, we file an eviction. And I'll have to, and I know that we have some that are pending.
What about if a tenant has a double homicide and 6 people shot?
Well, that would be a good reason to evict someone.
Okay, let me just ask you,
Sure.
straight out, Mr. Brown, do you support the city's position that 1145 should be closed?
Yes.
Thank you, nothing further.
I have a couple questions for you.
Yes, ma'am.
Do you collect any proceeds from either 1145 or the valet that aren't just basic rent?
From 1145, we receive their base rent, and from all the tenants, there are some common area maintenance, sometimes utilities, whatever's added on, yes.
Okay, but you don't receive a percentage of their profits?
Oh, no,
Okay.
no,
For either one?
no.
With valet? Okay. Is a valet essentially a tenant in the parking lot? They pay you?
Yeah, yeah, we have an agreement with them and they pay us weekly.
Okay. And you heard testimony from about guards at the door searching people. Did they work for the valet or did they work for the club?
Club.
Club. Okay. Okay, thank you. Anything based on the questions I just asked him?
No, thank you.
Okay.
No.
Okay, thank you.
Okay,
Appreciate it. You're done.
thank you.
Okay, I need to hear a warrant. Let's take a few minutes before closing arguments. Do you know where the officer is? They gave up. Okay.
We're in our office.
She can go right to the court reporter. And the other exhibits are right here with the court reporter too, if you need them in closing. Okay. What's your time estimate for closing, guys? How long do you think you're gonna talk?
I should, 30 minutes,
Okay.
and I want to allow, what time are you gonna allow us? Because I want to allow some of my time to the city attorney, the solicitor, Erica.
You wanna split your argument?
I want to split it, but I might have to say 45 minutes.
Okay. And how about you?
If I get to 20,
Okay, and how about you?
Probably about 20 or so.
Okay, sounds good. Okay, I'll be right back.
No, I said I was gonna share with her. I said, it's in solicitor, which is good. We may not have to. I don't want to do 20 minutes.
Yeah, they complain all the time.
Do too much, I don't know.
They just like
Don't beat a dead horse. Hit
anybody else that lives
your
in
prompts,
Oh, okay.
your bullet points, but the law.
No, I don't want to. So, no, but. I look tired, I feel good.
But I think add something to you.
Hi, go ahead. We had to. Go ahead, apologize to him.
yeah, that's what it is, she's the prosecutor.
Oh, yeah. It's okay, well, I'm fine. I know.
All right, thank you.
It's good to make cases. Did you leave it downstairs or the restroom?
Maybe in a restroom, I don't know. See, that's the thing, is silence. Yeah, because I don't want a noise in the middle of the court. So completely silent. I mean,
So my wife always finds it's the third time she was in the
that's why I carry a small purse.
Well, I have.
Carry a small purse, that's complex, I don't like to be doing this. But I think that I might have let you know where, when I'm walking inside the building at the security and So, do you think, how long did you think she said she was going to be?
Just a few minutes.
Oh,
Does she have time to go downstairs?
do I have
find
5
her phone?
minutes? I left my cell phone downstairs at the,
Go ahead, I'll tell her.
so,
Thank you.
let's call her Lois. She's probably like, where is she?
Yeah, I'm do it.
I'm blessed, I just have to. How far do you have to drive in the traffic? Oh, yeah, you told me.
Yeah.
That's not bad.
Not quite as far as you.
No. I just have to go up to North Ridge.
There you go.
It's not that bad.
Well,
It's a regular going traffic, really.
I guess that's the one, silver one. I usually, take 400 down and then I jump over to 285 and get off on Ashford Avenue. Because since they've redone it now, where you don't actually have to get onto it.
remain seated.
Oh, it's fine. Did you get enough time to do whatever you need to do?
How you
Okay.
doing, Your Honor?
Good, how are you doing?
Good, I wanna say,
Happy to hear from you.
finally you're gonna hear from me. I've been sitting here patiently.
That's hard to do,
Hopefully-
isn't it? It's hard to be the one that does
I've enjoyed my experience in your court. I want to say that first off. My name is Pat Dixon, and as I've been earlier introduced by my law partner, I wanted just to basically sum up where we are in these proceedings. We have consolidated the interlocutory permanent injunction for final hearing, which is allowed by the law. I've provided the court a hearing brief where the court can follow the law and also to give a written account of the factual background as to why a motion should be granted in this case. I believe that equitable relief is required in this circumstance because of the grave nature that has occurred here. We set out significant facts in the original petition for TRO, the injunctive and declaratory relief, as well as an amended one where we added some other basis for our claim here. In the injunction, we are seeking to enjoin this operation of South 1145 Club from operating in the city, at least in this location, and perhaps to be enjoined from ever operating a club of this type, which unfortunately became a death trap for the unwary. We're also seeking a declaratory judgment that would declare a nuisance. And before I get into, I want to just describe what nuisance is described in this state. It's a simple explanation or definition on OCGA 41-1-1, and this just describes a nuisance as anything that causes hurt, inconvenience, or damage to another. And the fact that the act done may otherwise be lawful shall not keep it from being a nuisance. This is the general definition of nuisance, and I think that the facts of this case fall well beyond the nuisance category. In this situation, this is a self-described contemporary club, as we've seen. We reviewed these facts forever over the last 2 days, but just to briefly say, it was not permitted. It was legal operating as a club when it was a restaurant. Patrons were allowed to bring ammunition and guns into the facility because the actual security was woefully inadequate. There was 270 calls of service from May 23 to May 24. The first frequency is important because the nuisance is not an isolated incident. It is frequent, regular, continuous. That's the way it's defined in the many cases that I've read in this area. And there was a fatal shooting here with 2 young women who were barely out of their teens with their whole lives ahead of them, being cut short because of the irresponsible management of this facility. So I'm just saying that we have a clear case of what a nuisance would be, and it just generated a criminal element. And remember the general definition, creating a criminal element can be a nuisance, as been indicated. I do have a case that's dispositive of this issue, but we're gonna do some deep, well, shallow drilling. I don't wanna go too, because it's late on a Friday evening. I have may I approach you on here? I've started this case, certainly in my brief. It's a case I rely on, and have relied on it for a while in litigating these nuisance cases. And it fits so well in this situation where it states, it's a short case, but it says a lot. It says, it first defines what is a public nuisance, and that's what we have here. I just defined the actual nuisance in general, but a public nuisance has a different definition, but they're not inconsistent. They all fit together in tandem. A public nuisance is one which damages all persons who come within the sphere of its operation, though it may vary in its effect on individuals. This language is used in the sense that every person in the area must not have actually been hurt or injured in order to show a public nuisance. It is sufficient if it injures those of the public who may actually come in contact with it. A public nuisance exists if the act complained of affects the rights which are common to all within a particular area. Now, in this case, in the Moreland case, the Supreme Court found that, and Judge Sears wrote this opinion. In this case, it was a nightclub, but it was legally operating, I guess. But this was a nuisance, illegal sale of alcohol to adults and minors. We have that here, well, at least illegal sale to adults. The illegal dealing of drugs, we did have smoking and marijuana on the premises. The outbreaks of numerous fights, including gunfights, we have that. The creation of significant traffic congestion, we have that. Loud music, we have that. And littering, we have that. And the court has found that having reviewed the record, we conclude that there was ample evidence presented to the trial court to authorize it to find the Countdown Lounge, that was the name of that lounge, constituted a nuisance. Now, the facts of this case, the facts of Moreland pales in comparison to what we have here. As I indicated, we even have the health and safety concerns that Moreland did not have. Now, Mr. Bailey talked, in his opening argument, he talked about we gotta have a cause or concurrent cause. Certainly that was, the way they behaved is the concurrent cause of this nuisance. It can be no question that this is the cause. And I want to say in terms of the public nuisance, it's not that everyone has to be harmed. And that's the Chain case. That's another case that's cited in the hearing brief. It's City of College Park versus 2600 Camp Creek LLC. It's the risk of harm that creates the nuisance. We noticed that a lot of witnesses said that they didn't feel safe as to what was going on. But this is what's important, that in the College Park case, we need not wait to the calamitous event to have a nuisance. But in this case, the calamitous event did occur. But the fact that it was risky, it was leading up to this. With the 270 calls, the officers, if you remember the testimony, they talk about it took up the bulk of the zone, going to these calls, trying to deal with these different issues.
The shootings, there were stabbings, there was evidence of stabbings in the facility, as well as the shooting from the place across the street. But still, it was an environment that basically nurtured the nuisance situation. Now, the thing about it is, there are cases that are less dramatic or serious in this case that have been declared a nuisance, such as I indicated in the Chancellor versus Hancock case, for instance. The court, and it's in my hearing brief, it said that a bad reputation in encouraging lottery, vagaries, and the tendency to breed crime was sufficient to establish a nuisance. And in that case, they had never been granted a liquor license. In this case, they had a liquor license, but it was for restaurants, so they were basically selling alcohol illegally. It was not, so as a result, that is sufficient for this court to declare a nuisance, the fact that they were selling alcohol illegally. And operating illegally. Another case that comes to mind is the Ford versus Crawford case. It's in the actual hearing brief, and it talks about, in that case, an undercover agent came to this lounge, and even though the owners, Mr. Bailey said the owners has to be the concurrent cause, even though the owner of the club, the owner or operator did not know that he did not participate in the drug sale, but he knew the person in his facility would sell drugs on a frequent basis. And the court said that as a result, the owner knew or should have known that that kind of action was taking place in that facility. And therefore, in the Ford case, that facility was declared a public nuisance. So in this situation, there are other factors that are a nuisance that are present here, such as inadequate security. Now, I've cited Camelot Club Condo Association versus Afara Hopi, as well as Bethany Group versus Grubman. And those cases are instructive. Those were private nuisances, but those cases dealt with inadequate security. And the court established that inadequate security can be a nuisance under Georgia law. Also, in the McBride case, where Mr. Bailey sought to distinguish, that case said that a clinic, this is an abortion clinic, a really controversial abortion clinic in Cobb County, where they said that even though the abortion clinic was operating with the license, but it could be a nuisance, it was not determined at that point because it was sent down on remand on another issue, but they said littering, folks relieving themselves, because it became, there was a lot of demonstration, there was a lot of commotion going on up there. And the tenants in that and matter of fact, I was in that, I had an office in that complex, so I can tell. I was very upset. Couldn't get into the office in the morning because of the demonstrations and all, and it was just a disaster. But they were relieving themselves in that whole, around the premises. They were littering, and it can be a nuisance. In another case, we're talking about in the Gillette case, where, and this cited as well, the Gillette case said an illegal gambling operation can be a nuisance. And in the Chancellor case, as mentioned, the illegal sales was a nuisance, as well as the fact that Chancellor did have some other problems as well, and it was declared a nuisance, not as significant as the problems in this case. So I'm saying that a nuisance, the definition saying that even a nuisance can be established even if the person or entity was operating illegally, long as it's caused a hurt and inconvenience. And so that's why I cited such cases as the Portland case, which Mr. Bailey tried to distinguish, where that was it is significant because that facility was operating legally, but it was very, it emitted noxious odors, and it disturbed the neighborhood. And even though they had the license to operate, it was nonetheless a nuisance. Also, in terms of the clinic in Benton case, they were operating legally, but it was a nuisance anyway because it was not the right facility in that particular neighborhood. So, and then there was a funeral home here that was declared a nuisance even though they had the proper license, but they were not fit for that particular neighborhood. So the nuisance boiled down to you can have the right thing, doing the right thing in the wrong place. In this situation, they were doing the wrong place in the wrong, they were doing the wrong thing in the wrong place. So they were doing two wrongs, which made an even greater wrong. So the damage is well established. And in this situation, you heard all the testimony, and there were 6 recurring dominant themes in this whole situation. You had illegal operation as a club, operating illegally. You had frequent calls, multiple calls, 270 calls. That's continuous and regular. You had inadequate security, that's the third theme. You had trash, debris, noise, traffic, congestion, public intoxication, public relieving themselves, and just generally a feeling of being unsafe in the neighborhood. And then you had the safe and healthy issues. You had building violations, mechanical, electrical, plumbing, you had fire, you had water cutoff, and then you had, and and also more important, the 6th recurring theme was the cause. Mr. Bailey said that perhaps his client was not the cause of this nuisance, but the most damning evidence on that is that when this facility was shut down, everything stopped. The multiple witnesses indicated that it is a peaceful environment now. So that is overwhelming evidence that the cause of this nuisance was none other than 1145. So let's just briefly walk through the evidence and see the recurring theme. That's a lot. I usually don't have that many themes. I got 6 in this case because this is egregious. This is uncalled for. Now, in terms of Major Van, in terms of his theme, homicide calls and other serious crimes, traffic congestion, noise, hours of operation. That comes within the theme. Hospital and Shepherd Center nearby. And we've set out, even though our testimony talked about it in general terms, we set out details of what those were in paragraph 36 to 47 of our verified complaint. But they were generally discussed throughout the testimony. And Officer Shames, he talked about inadequate security. There you go. That's a part that's making up the nuisance. He also said that if the club would have had adequate security, he would have indicated. He testified that he thought that the stabbing could have been prevented. Officer Walker talked about the fact that there were shootings, and he was he described the Freshmouth Market shooting, and there you go again, shooting, the danger to the community in that Buckhead community. And you know, there was some, I think that Mr. Bailey's going to talk about the fact that there were police officers in the on duty in the parking lot, but at the same time, those police officers could not they could not search anyone. There was no testimony that they could search because they cannot. Because of the SOPs, they're not in a position to search anyone, or are they allowed to do any bouncing. So the security that they would provide would be inadequate. What they didn't have is a system by which to search individuals using the club. They knew they had a problem, otherwise they would not have security. But they had inadequate security because, as indicated, that the actual one of the what was indicated was Detective Walker said that if the Detective Shingles indicated that he felt like it was inadequate in terms of that he testified about the stamping. And he felt that it was inadequate because there was no system by which they were looking into the purses of the young women who were attending the bar. So the actual searches were inadequate. There you go. And then the shooting, there was a shooting there. Then there were other factors involved. Officer Walker talked about the fact that he talked about the noise complaint. There you go. Then the recurring theme. He talked about the traffic backup. He talked about the bulk of the calls came as a result of calls to 1145. Now, LaToya Francis, she fell in the category of adequate security because she was hurt during the incident. As you've seen, the horrendous scene that occurred as a result of that fateful Mother's Day night. So then we have the testimony of Shakola Weston. She talked about the fact that they were charging $750 for a booth for a party, and then you had liquor sold by the bottles. Another violation of the rules. At the club. Now, another thing that each of these witnesses indicated, they indicated that it was definitely a club. I think almost to a person who had any close contact with the club testified that it was a club and not a restaurant. So it was clearly operating illegal. Shakira Walker, she testified the fact that it was a club, and she was one of the persons who was injured. There was a safety issue. That's one of the recurring themes. Tisha Murphy, I believe, she talked about the fact that the security was inconsistent. And she also indicated that it was one of the most terrifying nights of her life. Here you go, this theme of safety, security. John Weber, the director of the Terminus Ballet, he talked about it was a not a safe environment for his students. He operated a ballet company, and there was a smell of marijuana in the air. Egress and ingress to the facility was impeded. He was greatly concerned about his students. There again, he also testified to the fact that after it was shut down, there were no more problems. It became a very quiet community. Savasky, she testified that she had seen the long lines indicating it was a club. Here again, operating illegally. And the noise, she testified about the noise, the safety concerns. She also indicated that once it was shut down, all of the activity, the noise, the trash, ceased to exist. Then Jake Tumble, he talked about the noise, the safety, the gunshots. And when it was shut down, it became quiet again. Wilbur James, the water manager, as you heard, he talked about that the club owed $78,071.82 in water bills. So there you are, you have a club whose water bill has not been paid. It's beyond me how they're gonna be able to operate without sufficient water. You got Kelly Harrison. She testified as vice president of the Community Service Association. She talked about the very bad traffic, the noise, the shouting. She represents 315 members, so that's an indication that the impact to the community is significant. Therefore, the nuisance is a significant one. It's not just affecting a few people, it's affecting a lot of people. Mr. Recklin, he talked about the fact that he is the actual building inspection for the city. And it's interesting that he shows up on Sunday and they're there on Sunday. There again, that's the reason that you want to operate illegally as a club when you're a restaurant, because you could open on Sunday. In the city of Atlanta, you cannot operate on Sunday if you're a nightclub. There again, he indicated how unsafe it was, how many violations, the 8-unit ductless, the split systems, the UL illegal installation, the receptacles were illegal, no permit in many situations. So we have a unfit building that was unsafe for the public, and that was testimony that there was some use of this unsafe facility, and they continued to use it after the sign was posted that it was an unsafe area. Jessica Gardner, the code enforcement person, talked about the fact that how the actual owner came to the facility, came to her office, and he would not accept service on the citation. There was some talk about Mr. Baylor's indicating that there was citations. There was no citations, but he would evade service on the citations. So that was an indication that he's not going to comply with the requirements of the code. He went to the extent of evading service for the citation. So the argument that the city did not cite him for the violations just will fall on deaf ears. Fred Coleman, the fire department investigator, indicated that he went to the facility, saw that it was the actual unsafe placard there, and he deemed it the building unsafe as a result. Dara Jones, the auditor, the city auditor, indicated, the manager of auditors of audits at the city, indicated that the facility did not pass the fact that it was a restaurant, because in the city, you must have the food sales must exceed the alcohol sales. And his findings were that the alcohol sales exceeded the food sales, so it was operating as a nightclub. Benjamin Gaines, the revenue collection manager, indicated that they had been delinquent and have continued to be delinquent in their tax by the drink sales. So as a result, they have continued to ignore the law, disregard the law, and we think that this club is, as a result, is operating illegally. There you go again. Mark Carter, who is the police lieutenant who's over the liquor license enforcement unit. He also was able to confirm that if the food does not exceed the alcohol, then it is operating as a club. But what's more importantly there is that I can hear in Mr. Bailey's argument that because the city did not cite the club, in some way it must be innocent and it must be exonerated. The reason for that was that apparently the city is overwhelmed, and they cannot write a due cause or issue due cause on all the many establishments in the city. So in this case, but he's moving forward with a due cause. It's failure to supervise, as his testimony showed. an indication that this place is operating illegally as a nightclub when it should be a restaurant. And a violation of the tax paid by the drink, it has shown. So, I'm seeing all of this. And then we got some admissions. They have admitted to the fact that their own employees have admitted to 3 things: that they are smoking marijuana in the club. She indicated that. Number 2, there were gunfights. She indicated to the fact that it was liquor sales. She talked about the sale by the bottle. She admitted to the traffic congestion. And she admitted that it was a nightclub as opposed to, she said, a nightclub experience as opposed to a restaurant. So the evidence is overwhelming. So we think that in weighing the equities, and that's what the court has to do in this circumstance, it has to weigh the equities in issuing an injunctive relief. And we think it's clearly shown, as we've shown in our brief, that the equities weigh in favor of the city in terms of in making your determination that injunctive relief or permanent relief is in order. Now, we balance the equities. The harm is irreparable. A death has occurred. There's no adequate remedy at law because of the fact that Mr. Bailey is talking about, let's go through the enforcement process. That process is basically, and we've had testimony that it's overwhelmed. It's too slow, and it has to be, it's not an adequate remedy when a nuisance exists. There's no law that would preclude us from pursuing the nuisance remedy just because we have a code enforcement mechanism. It's been shown that that mechanism is inadequate under the circumstances of this case. And therefore, there is no adequate remedy in law, and we're asking this court to enjoin this club. Now, did I take too much of my time?
You didn't take too much time. I heard everything I needed, but can I ask you a couple questions?
Yes, you can.
Tell me specifically what you would want me to enjoin Bennett Street from doing. What are you asking me as to Bennett Street?
Well, I tell you, Bennett Street, we want to enjoin Bennett Street from further participation in this process.
Do you think I have the authority to make them sue to break the lease?
I think that if you declare a nuisance, then they are bound to, they have grounds to basically file a dispossession action. Because
so you're essentially asking to enjoin Bennett Street from permitting continuous activity as alleged in your petition.
yes, I think Bennett Street has some responsibility. Now, let me tell you something, what I think part and parcel of this nuisance action. And even though able counsel has done a significant, a yeoman's job of trying to distance herself from Mr. Bailey. But the problem with that is that they are part and parcel of this whole process. You see no evil, hear no evil, talk no evil, and so forth. Therefore, I don't have any responsibility. They knew the circumstances that were happening. And I think that you have the power to require that they dispossess this tenant because pursuant to their own lease, there's a provision there that requires or will allow dispossessory if a nuisance is created. So if we establish a nuisance and they fail to dispossess this tenant, then in fact they have, there's no explanation for failing to do so. There's no reason, no excuse for failing to do so. I represented the enforcement, the actual code enforcement board for a number of years, and we folks would have tenants on their property. And we would not even worry about going after the tenants. We would always go after the landowner. And the landowner would come in and say, okay, I couldn't eradicate these problems because my tenant is on the property. Well, have you filed a dispensary? And they say no. Well, that's still your problem. That's still your property. You still have some control. And they have not relinquished all control, even though there's a lot to be said about relinquishing control of property. But when you look at it, they can enter that property by giving, his testimony today was, they can enter that property by giving a 24-hour notice. So they did have some control. So it's part and parcel. They are part and parcel. So they're in this together. So I think your order can direct them to take action to help eliminate the nuisance.
Okay,
Okay.
thank you.
Thank you.
Thank you very much.
Thank you. Okay, which one of you two would like to go next?
I can go, yeah, if you don't mind. Especially because we end up talking about Bennett and then it would be easier for me.
So, oh, I'm sorry. Your Honor, I'm not gonna repeat what all the witnesses said and everything that, was exposed here. You heard all the testimony. But I'm just gonna repeat the law again. No, CJA 44-714 provides that having fully parted with possession and the right of possession, the landlord is not responsible to third persons for damages resulting from the negligence or illegal use of the premises by the tenant, provided the landlord is responsible for damages arising from defective construction, damages arising from failure to keep the premises in repair. I didn't hear anything on those hearings that are talking about failing construction. This building is an older building, and the building itself has absolutely no failures in construction or failure to keep the premises in repair. And even if it was failure to keep the premises in repair, the contract establishes that the tenant was actually responsible for all the repairs while using the property. Now, have a particular case is Diffley versus Marshalls East Lake. This is the Court of Appeals of Georgia, 227 Georgia Appeals 343. And again, talking about in the size of the nuisance, the case says exactly the same thing, that the statutory limitation that I just read, for the landlord's liability to third parties, it applies equally to and includes uses of leased premises that create a nuisance. Whatever may be the character of the nuisance, the action must be brought against the person who creates or maintains it. Bennett Street did not create the nuisance. Bennett Street did not maintain the nuisance. Bennett Street is a private, is a real estate partnership that has, as you heard, more than 18 other tenants in the same property. They have 2 people basically working in the office. They are not even in the office every day. And now the city is trying to impose to this private, this landlord, to fix the problem. When we heard that, they kept renewing their alcohol license. They kept renewing the business license. They never cut the water before what happened in May, although there was $78,000 not paid. They didn't, they never were cited for noise, although they had the power to do all of that. Actually, I think I heard the testimony Citations were not issued at any point, although people actually went there and inspected. Now the landlord, who was never cited for anything, he was never notified of everything, he has to be here, come here, respond to that. And then the city is basically like, oh, we were too overwhelmed. Why don't you just go ahead and file a lawsuit and all the expenses and try to prove breach of contract and go ahead and take this tenant out of there? From the beginning of this case, Bennett Street never opposed the city. Although, yes, if the business is closed, as it has been closed, we have not received our rent. But we are actually just expecting this to end so we can, clean up the property and either try to lease to somebody else. And of course, believe me, next time we'll make sure, it's not the same type of business. But it had been running as a restaurant for more than 40 years without problems. So we had one bad tenant, and then we are the ones that have to fix the problem because something horrible did happen. But again, Bennett Street, it's not the one who caused it, who created any of those issues, that maintained any of those issues. So, I do not agree that Your Honor would have the jurisdiction, the power to order a private, company to file suit against another on a contract basis. But, but we are not in a position even to file an eviction. But this lawsuit was already happening, and the moment your owner declares that 1145 is a nuisance and it prohibits his operation, then there might not even be a necessity for Bennett Street to go ahead and file an eviction because they're probably just gonna leave. And to our, if you stop and think about it, Bennett Street is, of course, I'm not comparing Bennett Street properties with the victims of the shooting. But when it comes to the city closing the business, they don't pay in the water, Bennett Street property is the one that is gonna have to cover, financially for all those losses. So, on regards of the water and the rent that it has not been receiving. So in a way, Bennett Street is also the victim of a business that did not, fulfill its obligations. But I would request that for us to be dismissed. I don't understand. I asked the city, what do you want from us? Why are we here? And they said, well, to evict them. Well, we're not opposing you. Let's see what the judge is gonna decide in this case. I appreciate it.
The devil's in the details, and it's important for this court to not get lost in these series of broad conclusions by the city that lacks evidentiary support. Your Honor, I mentioned earlier in my opening statement that in May of 2024, the city decided that it was going to declare 1145 a nuisance. Despite what the evidence supported, that was the conclusion the city had already made. After making that determination and after filing this nuisance suit, the city begins to contact all of these departments in search of support for this finding. That's why we're here today. Not because the evidence led us there, but because the city made that determination. Now, you've had an opportunity to listen to witnesses over the past 2 days. In the city's complaint, they mentioned these 12 violent acts at 1145. However, the evidence did not support 12 violent acts at 1145. There were not 12 violent incidents at that establishment. Instead, the evidence supported there was one shooting inside the establishment. Not two, not three, one. Not one officer, not one citizen, not one neighboring business could identify any other shootings besides that inside the establishment. They mentioned one incident in the bathroom that an officer mentioned about a report. We didn't even hear from the victims to determine the veracity of those claims. But in that one incident, there's no evidence that was presented that 1145 was even aware of that incident. So that means that prior to May 12th of 2024, there's no evidence that 1145 was aware of any violent incidents inside the establishment. Now, everybody knows about the recent assassination attempt on Donald Trump. Running for president of the United States, he had Secret Service guarding him, and even they couldn't prevent one isolated incident. Now, Major Vance testified that he received a number of calls. 270 calls, what he said, in the area. He said 1145, but really it was in the area. However, he calls 1145 the epicenter of crime, but he couldn't name of any citations to the business. He couldn't name of any incidents directly at the business. He did mention receiving calls for other businesses. He did remember citations for other businesses, more specifically hours of operation, for other establishments on Bennett Street that were cited, but he knew of no citations for 1145. Now, the city wants to use the term 1145. They want to make that term synonymous to pretty much the top of Bennett Street. So they want to include the parking lot and the rest of Bennett Street. Multiple witnesses that testified referred to the club's valet. That's very important because nearly every witness that testified attributed that valet in that parking lot to 1145. As you witnessed, certain witnesses on the stand just learned today or yesterday that wasn't actually owned or operated by 1145. As you heard in the testimony, the club doesn't have a valet. The club doesn't hire a valet. The club doesn't even control the valet. They don't manage the valet. Heck, they don't even receive any money from the valet. Further, as you heard, the valet is not even exclusive to 1145. It's for any business on the street. It's not even exclusive to the restaurants or lounges, for any business. You know, and going with the theme of the city attempting to tie everything in 1145, you heard testimony from one officer who talked about an incident that happened at 1145. But then on cross, he admitted that the victim said it happened at 1145. Then the victim said it happened at the BP. Then he said it happened outside. I mean, so basically, we're supposed to rely on hearsay testimony from an officer, hear something from the victim, who couldn't even confirm he was at 1145. Now, despite the fact that 1145 prior to May 12th had zero notice of any violent incidents inside the business, they still chose to hire security. As you heard, they had security on the inside and the outside. On the outside, the business actually hired APD officers as well. Now, in testimony, you didn't hear that there's any requirement for any restaurants to have security on the inside or the outside. There's no testimony to that fact. They talk about negligent security, but 1145 actually attempted to prevent any weapons inside their establishment. They actually hired security on the inside and officers on the outside. Not only is that not required for a restaurant, it's not required for a club. So it's immaterial whether that is a restaurant or a club. Security wasn't required. They had no previous incidents, no previous violent incidents inside the establishment. Now, the city spoke about how APD officers are not allowed to search patrons, they're not allowed to patrol the inside of the premises, but the witness did testify they are allowed to make arrests on the outside. They are allowed to monitor and patrol the outside. Well, guess what? 1145 did have officers outside the premises. In fact, the officer who responded to the May 12th scene talked about getting access to the security camera. She talked about waiting for the warrant, but then when questioned about how she got access to the security camera, she said it was provided to her by an officer who was already on the scene. An officer who was already there working at 1145. That's how she got it. Now, conveniently, the city wants to dismiss the fact that there are other restaurants, lounges, or clubs on Bennett Street. However, the testimony revealed that the city had knowledge of at least 2 other shootings that happened inside businesses on Bennett Street. I didn't hear any evidence, and the city did not the city testified they not brought any nuisance claims against those businesses, but they did bring due cause at least against one business on that street. Now, I think the court can agree that the city fell short of satisfying the standard that 1145 is a nuisance that damages all persons who come within the sphere of its operation. As stated earlier in the League v. City of Atlanta case, a single isolated incident or act which, if regularly repeated, would constitute a nuisance. It's not a nuisance. So as I stated, there's been one act inside the club that the city is trying to use to fuel their argument that 1145 is a nuisance. You heard from witnesses. Dick Turnbell admitted that he personally feels safe. He personally felt safe, and he admitted that the sentiments of his employees were primarily neutral. So obviously they weren't damaged by this alleged nuisance. Now that brings us back full circle to all the allegations in the city's original complaint, which I'll circle to later. Because they could not prove there's a single incident, the only thing they could do is bring up all these other issues that they added in their amended complaint that was filed last week. So that they reached out to all these departments to see what they could find. Unfortunately, they didn't deliver what they thought they'd deliver. So the next thing we go to is control of harm. Now, I'll revert back to the McBrayer case that I mentioned and counsel mentioned as well. The Court of Appeals has consistently held that under Georgia law, in order to be liable for a nuisance, ownership of land by the tortfeasor is not an element, but control is. The essential element in nuisance is control over the harm. Now, the city did not prove, nor did they even allege, they didn't prove that 1145 is involved in any criminal activities. Nor did they allege that 1145 is even correlated with the crime. But what they do allege is that it's the way that the business, the way it conducts business creates and maintains a nuisance. Well, essentially they want the court to believe that if 1145 was not operating there, there'd be no crime. That is just not the case. The facts do not support this. The facts show that the facts show that not only was there already crime on Bennett Street, but there's been shootings on Bennett Street and at least 2 other businesses. Now, the city just recently cited earlier, they cited again the Moreland versus Cheney case. But that case is distinguishable, as I mentioned earlier, but that's a situation where the nightclub had pervasive problems, in the word of the court, that was generated by the defendants. In that case, they speak about the legal sale of alcohol to adults and minors, not just the minors, adults and minors, the illegal dealing of drugs, the outbreak of numerous fights, not the outbreak of 1 or 2, the outbreak of gunfights, plural, gunfights, and the creation of significant traffic congestion, loud music, and littering. Now, as I stated in my opening, the city was and is aware that this case it resolves around one nuisance. Now, what happens? Well, instead of providing you with evidence about more than one nuisance, the city focused on one specific incident that 3 witnesses testify that. Now, so what can the city do when they cannot prove that this is a continuous issue? They go to the ordinance violations that I mentioned. In my opening, I warned that this was their way of showing there's a pattern there's a pattern that they needed to establish these nuisances, but all of these fell short. So let me kind of dive into these alleged violations. One was noise. Now, as mentioned, the witnesses testified. You had different witnesses that testified they heard noise coming from 1145. The majority of them could not even identify where the actual violations came from, but guess what? There's not one citation. Not one citation for noise. An officer testified that the procedure is to issue a warning the first time they receive a complaint, then to write a citation if they have to come back. But there's nothing preventing them from issuing a citation the first time. He did not testify that he's prevented from giving citations the first time he receives a complaint. But that was just smoke and mirrors. The city threw that in there, as I mentioned, because they knew they didn't have enough evidence. They knew they didn't have enough evidence in the original complaint. The next one was trash. This one, once again, not one citation for trash. Not one citation for junk trash or debris. There's no evidence that trash is actually outside of 1145. To the extent that there is actually trash inside the parking lot across from 1145, that's not in the control of 1145. That's not in the management of, under the management of 1145. However, there was testimony that one business owner did see trash in the streets every now and then, is what she said. And she said she couldn't remember how often. She said, but maybe every 3 months or so, when the person who was hired, and you heard testimony from the landlord, there's a person hired 7 days a week, when the person who was hired was maybe late to clean up trash in the mornings. Now, when we go to the building and fire codes, we talk about, I didn't even want to address these, but because the city has spent so much time on these, I feel like it's necessary. The city has talked about how there's a patio that's built. But what you heard in the testimony too, 1145, they did apply for a permit. They did have and you heard from testimony, they need to have a license, they had to have a licensed contractor or a licensed specialist to apply for those permits. In testimony with the building inspector, after the initial stop work order, there was additional applications sent to the city. And there's testimony that after the work order, there's no evidence, and there's testimony to support that after the work order was issued, 1145 did not utilize that patio anymore. So those ordinance violations do not rise to the level of a nuisance for a patio that was built that they're not even utilizing anymore. The city didn't testify that they cited for a stop work order and they kept operating and using this patio despite the stop work order. We talked about they talked about the witness from the zoning department testified that she tried to serve 1145. She also testified that she has the ability to serve any person related to the business. She can serve the property owner, she can serve the owner, she can even serve an employee. So she said that they went to the business 2 times that she knew of in an attempt to serve 1145. Well, it's not that difficult to look online and find the hours that they're open and operating. And at some point, if this was a nuisance that needed to be abated, or this is a nuisance that the city needed to deal with, it wouldn't be that difficult to find a day they're open and serve any employee. So if Mr. Dockey did not want to accept the citation, she had about 30 or 40 other employees that she could try to see if they accept the citation. But there's no evidence to support that they went more than 2 times, and no evidence to support that they tried recently. Now, the water bill might be the most ridiculous allegation to be tied in here. It looks bad, $74,000. It looks bad, but the city doesn't allege, there's no evidence that 1145 operated without a water. I mean, if the city wants to 1145 not to operate with water, all they have to do is turn off the water till the bill is taken care of. That's a very simple solution. It doesn't put anybody at risk. It's not a health or safety risk. There's no evidence to support that 1145 was even contemplating to operate that way. But this was just thrown in there because, once again, we have to establish this continuous pattern of nuisance. So they just got to throw that in there. Now, once again, all these things were brought up, not in the original complaint. They were brought up a week ago as the city attempted to produce this pattern when they decided they knew they didn't have evidence to support the 12 violent incidents. So now we get to the common theme that the city is relying on too. We get to the city claims that 1145 is a club. I think almost every witness produced by the city, including the witnesses produced by the respondents, the city's asked them, what do you think 1145 is? What do you know 1145 to be? But as I said in my opening, a layperson's definition of certain terms is different than the legal definition. And as you learned today, the legal definition of a club is not the same as a layperson's definition of a club. In fact, the city brought their witness, the expert who could tell the court, who could define the club better than any other person in this courtroom. They brought Lieutenant Cotter and asked him, was 1145 a club? His response, he said, that's hard to say. Lieutenant Cotter said, that's hard to say. Now, also, Lieutenant Cotter said that he had been at this establishment on, I believe it was around 40 compliance checks, no citations. This is the expert. This is the expert. Even after hearing that, the city just wants to, they want to just instill in our mind that this is a club, this is a club, this is a club. But guess what? even if 1145 was a club, that has no bearing on this case. Witnesses testified they believed it was a club because there was partying. Well, guess what? As the testimony showed, there's nothing illegal about partying in restaurants either. Witnesses testified that they believe it's a club because it charges an entry fee. Guess what? There's nothing in the ordinance. Your testimony is nothing in the ordinance stopping any business as a restaurant or a nightclub from charging an entrance fee. Witnesses testified because there are lines and DJs. Once again, none of these things are illegal. None of these acts are forbidden for any other type of establishment. And most importantly, a club, by definition, is not a nuisance. Now, 1145 did not just change its manner of operation this year. They didn't change it last year. It's been operating the same way since it was originally licensed almost a decade ago. Now, the burden is on the city. You know, it's not a nuisance, but the burden is on the city to get injunctive relief to prove that there is grave danger to person or property rights. That must be shown prior to authorizing an injunction. But of equal importance in authorizing an injunction is that there must not be any adequate remedy at law. Now, the city if the city had an issue with the manner of operation, they had remedies to address them. They still have remedies to address them. They understand. They know there are adequate remedies to address them. Now, the city mentioned the appellate process, and there's testimony about that, and how the appellate process may allow business to operate while appeals are taking place. However, on the record, you also heard from section 109F, where it says, for a due cause, if a violation of this chapter occurs which results in an emergency situation in which continued operation of the premises by the licensee endangers the health, welfare, or safety of the public, the mayor or the mayor's designee may suspend any license, and any such suspension may be made effective immediately and shall remain in force until the next regular or called meeting of License Review Board. Now, I think that's very important. Very important, because the city is claiming this is a nuisance, and that but for the court intervening, they will not be able to stop this nuisance and prevent harm to everybody who comes to this sphere. But here we go. In their own alcohol code is a mechanism for the city to suspend the license of the establishment immediately. And not only that, but Lieutenant Cotter confirmed in his testimony that although the License Review Board can meet as soon as 5 days after that action, the mayor does not even have to sign the alcohol license. The mayor does not have any time limit to make a finding after the suspension goes to License Review Board. That means that the mayor can sit back and let that license be suspended until, what Lieutenant Cotter said, until there's a change in administration. The reason that was put in place is because in the past there were liquor license suspensions and due causes that happened, that mayors would sit on them sometimes. So then the next mayor would come in there, and the city wouldn't know, the neighbors wouldn't know what happened to this action, because it went to the License Review Board, they made a finding, and the mayor didn't act. So sometimes the mayor didn't act. But in this scenario, this is a remedy that the city could have used. They could have used already, but instead they're not using it. Now, additionally, we're dealing with a business that voluntarily shut down the day after that May 12th incident. They shut down. They shut down for over 20 days immediately. Then, prior to the other hearing, they agreed to shut down for another 60 days. These actions are unprecedented actions. Now, the city cannot just preemptively decide that it refuses to exercise its powers and turn to the court of equity for relief. The city has not exhausted its resources as it would have you to believe. I spoke about it earlier, about the zoning official testified that they could cite any employee. You heard in testimony that the business license department did not reach out or the business license department, although the witness testified he began the audit prior to May 12th, there is no evidence to show that he did besides his word. But he also testified that it was a random audit, yet there was evidence to suggest that Lieutenant Cotter reached out to that business official the night of the shooting. Now, once again, these adequate remedies, that's very important because the city has to show there's no adequate remedy. I just showed it right here. That's an adequate remedy. Shut down. Now, the city may argue, well, the business can operate without alcohol. Well, the city's arguing it's a club and that it barely sells food. So how is a business going to operate without alcohol if the city's saying it's a club? Which one is it? So they have an adequate remedy. And once again, I said this in the open. I have to repeat this again. The state EX RDL Boykin versus Ball and Vesco case, where it says if the penalties there provided be not a sufficient check to the abuses described in this case, the appeal would be made to the lawmakers and not to the Court of Equity, whose power can never be invoked where the law has provided what it deems to be an adequate remedy. Now, the city's complaint and the city's evidence fails to meet the necessary elements of a public nuisance. To grant the city's requests would overturn precedent in Georgia courts on what's required to show a public nuisance. To shut down this business that's been operating for years, operating lawfully without any allegation or evidence that has caused or contributed to crime or nuisance, is a dangerous position to take. And it would ignore controlling precedent. The court must not allow the city to just arbitrarily shut down businesses that it seems to be a nuisance. It has to be backed up by facts. Now, we're very sad and empathetic to the events that happened on May 12th. For that reason, that is why we shut down. 1145 shut down immediately. They shut down to review safety protocols, to reassess what they're going to do going forward. And the evidence that the city used today was primarily about the feelings and the pressure from the neighborhood. They talked about, in all this evidence, you heard people about feeling unsafe or things of that nature, but feelings aren't facts. And feelings don't control, facts do. We cannot allow the emotions to create bad law. Now, to the extent we made an argument that we do not believe this is a nuisance, but to the extent that the court does make a ruling, they have the power to abate. But we took those appropriate measures. We shut down. 1145 does not open back up. 1145 has made a commitment to operate 6 days a week. 1145 is producing a new menu. 1145 right after the shooting ordered metal detectors. I don't know how many restaurants or clubs have metal detectors in Atlanta. But 1145's had one violent incident, one shooting inside their establishment over almost a decade of operation. They still took that measure to do that. So to the extent that the court does make a decision, which we do not believe to be based on law, we believe that we have taken measures to abate that nuisance. Thank you very much.
Thank you. Did you have another brief argument? No. I'm not asking for more argument. Okay.
I do have, I want to make one point.
That's okay. You can make one point.
Yeah,
if you
I
want to.
want to make one point. And the thing about it is, he says it's an adequate remedy law. I don't see it as that because it's never been used. It's probably because it's fraught with due process questions. I don't know if you can just take somebody's livelihood without a hearing. So I don't think that's adequate remedy law. Now, in terms of the case that Mr. Bailey cited, that's a 1948 case. That case stands for nothing in its sense. It basically stood on the fact that the Attorney General of the state brought that case when the solicitor should have brought it. And another thing about it, it said that giving loans to usurious loans would not stand as a nuisance under the definition of nuisance. So
it was not about having an adequate remnant law. It was about the folks didn't have standing to bring the case, and it was not in the traditional sense of a nuisance. This is, we have case law indicate that this situation falls in terms of the blind tiger, which is selling spirituous liquor without a license, with like illegal gaming houses, and also the Morley case. So we have clearly a nuisance under these circumstances. That was not a nuisance in the working case, under the traditional sense,
Okay.
or in the established sense. Thank you, Your Honor, for your time.
Okay, I want to thank all the counsel for how you comported yourself during the course of this case, and the court is ready to rule.
Your Honor, I apologize for the interruption at this late hour. If I may be briefly heard on the matter of bond for Mr. Daffy when it's appropriate, if the court has a moment. There has been an agreement reached between the prosecutor out of the non-complex division.
You guys have a consent bond?
I do. I've received, yes, that's correct.
Okay, well, I'll announce the ruling, and then I'll take a look at that. I am presiding this week, so typically it's not my bond to sign, but if everybody else is gone, I think that's a good reason for me to take it.
Thank you, Judge.
Okay, thank you. All right, again, thanks to everybody for how you comported yourself during this trial. We did have some complications through the trial, and I appreciate how you rebounded from that. This court finds there's sufficient evidence that was presented that conditions created by 1145, which clearly was operating as a nightclub, were in fact a nuisance to those members of the public who came into contact with it regularly when it was open for business. Because a public nuisance, as noted by Mr. Dixon, may vary in its effects on individuals, the city doesn't have to wait for a calamitous effect to occur. It simply needs to significantly interfere with public safety. In this case, again, as noted by Mr. Dixon, a calamitous event did occur on May 12th of 2024 when both patrons and passersby were impacted greatly by a mass shooting. Sufficient evidence was presented to demonstrate routine interference with the public safety, the public peace, the public comfort, and the public convenience in this case based on numerous pervasive problems that were generated by and occurred in and around this lounge. These problems included the illegal sale of alcohol to minors and adults, the illegal permitting of patrons to use drugs, the outbreak of numerous fights, including gunfights and stabbings, a failure to properly screen guests, and the creation of dramatic traffic congestion, loud music, and littering. Further, I'll note that these nuisances occurred in the immediate area of a major hospital and specialty emergency medical provider. This is an especially dangerous location for traffic patterns to be significantly impacted. Finally, this court finds that no adequate remedy in law exists, and the evidence supports an injunction to abate this nuisance. The evidence is sufficient to convince this court that citation and suspension of licenses is not sufficient to abate this nuisance, based on the facts, as the business appears to disregard licensing and lease requirements. The court has no confidence that he would modify his business practices based on a municipal citation. Further, it's not clear that all the issues here are alcohol related. And I'll note, this court had to take Mr. DeFay into custody during this trial because he failed to appear to answer felony charges that he currently faces. They're totally unrelated to this case. Even if the citation process could abate or somewhat abate some of the issues, the operator has a history of actively avoiding notice of citations and oscillating between truing up accounts, water and taxes, and having large arrearages to appear compliant for enough time to avoid legal consequence. Thus, this court has found that 1145 is in fact a public nuisance, and petitioners request that the court issue an order permanently enjoining and prohibiting respondents from holding events, serving patrons, or conducting and or allowing any other manner of operation on the property as set forth in the petition, and the amended petition is hereby granted. More specifically, as to respondent Bennett Street properties, the same is enjoined from permitting co-respondent from continuing the same or similar activity rebranded under a new name. More specifically, as to respondents DeFay, 1145, and Sovereign Entertainment, the same are enjoined from operating a nightclub as defined in the law at this location, regardless of rebranding with a new name or possession of a restaurant license. Will you prepare an order?
Yes, Your Honor.
Thank you.
Thank you so much.
Thank you, Your Honor.
Okay, we can take up that bond matter now.
Thank you. I think what may be most appropriate, Joya Rutland in the district attorney's office, I communicated with her, she was assigned to the case. She actually sent me an email to confirm the nature of the consent bond. I'm happy to provide it to you and push forward.
Okay, come on up.
You're at work right now, right? Okay, cool. I just wanted to let you know, I don't know if the switch is still booked on this 11:45 hearing, but it just wrapped up and we are done. So I'm gonna take down the shot. Hey, no problem.